Good morning to everyone. I hope everyone's well and ready to start day 4 of this hearing. Is there anything we need to raise before we start?
Good morning, Madam President. Yes, I just wanted to raise one housekeeping matter. The respondents anticipate that we will complete the cross-examination of the, claimants anticipate completing the cross-examination of respondents' fact witnesses by around 3 p.m. this afternoon. So we will have our first expert, Mrs. Tomic Brkushanin, ready to go at 3 o'clock. We wanted to let everyone know that. If, obviously, we're in the hands of the respondents as to how long that will take, but if they anticipate that we should have the next witness after that, Mr. Miloš Milošević, ready, if they could let us know after the lunch break, we will have him ready as well today. Thank you.
Thank you. Any comments on this? I understand that you had anticipated for Mrs. Tomic, 45 minutes for the cross, and then Mr. Milošević is quite longer. So maybe it would make, seeing it from now, it may change as we go along. It might be a good idea to take Mrs. Tomic, but Mr. Milošević may be probably too tight. Or we have to break his examination, which is not ideal.
We think that it might be the best way to proceed to have Mr. Milošević tomorrow morning.
Yeah. But
That's fine
it's
with
probably reasonable. Yeah. Good. Then let's proceed on this basis. And is there anything on your side you wish to raise now? No.
No, Madam President.
Good. Then we can start with the examination of Mrs. Vukovic. Good morning, madam. Do you hear the interpretation when I speak? Good. You have been since 2016 the chief of the Department for Control of Performance at the Privatization Agency.
Just a small correction. Since 2016, I'm head of the unit for control of agreements at the Ministry of Economy. And from 2006 to 2016, I was head of the control department at the Privatization Agency.
You have provided one witness statement in this arbitration that is dated the 22nd of January 2020. Is that right?
Yes, it is right.
Yes.
Imam.
Good.
Yes, I do.
As a witness, you're under duty to tell us the truth. Can you please read the witness declaration that is in your on your table?
Sorry.
Of course. I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So I first turn to respondents for some direct questions.
Thank you, Madam President. Ms. Vučković, would you please tell us who commissioned the preparation of the audit reports which the buyer of the capital in BD Agro, Mr. Obradovich, delivered in the period from 2011 to 2015?
Yes, Mr. Obradovich commissioned all the audit reports that were submitted in that period.
Received several audit reports in that period. Have these audit reports dealt with all breaches of the privatization agreement for which the agency was leaving additional periods?
Yes, that's right. All the audit reports submitted in this period dealt with the issues that were the subject of the additional deadlines.
And to the auditors used for the preparation of those auditors' reports?
The documentation was always submitted by the entity undergoing privatization, of course, in cooperation with the buyer.
Opinion, was it clear to the buyer of the capital which breaches of the privatization agreement was he supposed to remedy exactly?
Of course, it was clear to him. This is confirmed by the audit report submitted by him in this period.
You are mentioning that in September 2015, Mr. Obradovich delivered to the agency the documents related to deletion of some mortgage. And were these documents related to deletion of the mortgage that was established as the security of the 2021 million loan or not? Could you explain that?
The interpreter apologizes. I didn't hear the year of the loan.
Do I need to repeat the question maybe for the translators? Yes? I'll do that. In your witness statement, you are mentioning that in September 2015, Mr. Obradovich delivered to the agency some documents related to deletion of some mortgage. And were these documents related to deletion of the mortgage that was established as the security of the 221 million loan or not? Could you explain that?
Yes, of course. Given the actions of the buyer regarding the additional deadline, we could see two ways of behavior of the buyer when it comes to the obligation of 534. The first one had to do with the third party taking a loan and having a mortgage on the assets of the entity undergoing privatization. This was the loan that Crveni Signal took from Agrobanka. That was 65 million dinars, and there was a mortgage on the assets of the entity undergoing privatization. The other way of breaching this contractual obligation had to do with the fact that the entity undergoing privatization took a loan of 221 million from the bank and registered a mortgage on the assets, and the loan was used by third parties. More specifically, loans were given to the legal persons Crveni Signal and Inex Nova Varoš. In this way, the buyer was in breach of the contractual obligation from 534, and in the additional deadline, he only sent the evidence regarding the remedy, regarding the obligation of the loan of Crveni Signal, which was 65 million dinars. And during 2015, he submitted the evidence that he had deleted this mortgage, which was the subject of this additional deadline, the deletion of this mortgage. As for the second loan, that also constituted a breach of the contractual obligation and had to do with the fact that the entity undergoing privatization took a loan, registered a mortgage, and then used less than 50% of these funds to other legal persons as a third party, Crveni Signal and Inex Nova Varoš. And of course, the buyer was asked to return those funds, which he never did.
Thank you, Ms. Vučković. I have no further question. Thank you, Madam President.
Thank you. Do I turn to you, Mr. Mizetic?
Yes, thank you, Madam President. Good morning, Ms. Vučković.
Good morning.
First, I'd just like to tell you that we're going to be going through some documents today. You have Ms. Penjer sitting next to you to the right, and she has a complete book of the original documents in Serbian for you if you need them. If you have any difficulties finding a document, feel free to ask Ms. Penjer to assist you, and she'll be happy to locate documents for you. Okay.
Thank you.
So first, I should have said my name is Luka Mišetić, and I represent the claimants in this action. I will be asking you a few questions this morning. You were asked some background questions by the president of the tribunal. I just wanted to ask you another question on that. You, as the director for the Center for Control of Performance Agreements, reported to the Commission for Control of Performance Obligations, correct?
Tako je.
Yes, that's correct.
And you yourself were not a member of the commission, correct?
Nije.
Yes, that's correct. I wasn't a member of the commission. I didn't have a voting right and I didn't take decisions.
The next question is whether you had a voting right, so thank you. Let me turn now to your witness statement at paragraph 6. And at paragraph 6, you state that you had a large number of meetings with Mr. Obradovich. Do you see that?
Tako je.
Yes, that's right.
From January of 2014 until the agreement was terminated, how many meetings did you have with Mr. Obradovich?
Ja se izvinjam.
I apologize. I really cannot give you a precise answer.
Did you ever meet with Mr. Obradovich in 2014 or 2015 to discuss assignment of the privatization agreement?
Ne sjećam.
I do not remember precisely, but I don't think I did.
You say at paragraph 7 of your statement, all oral and written communication regarding performance of contractual obligations was conducted with Mr. Obradovich as the buyer of the capital. Do you see that?
Vidim.
Yes, I do.
Didn't you have oral communications about the performance of contractual obligations in 2014 and 2015 with Mr. Markicevic and Mr. Braško?
Dozvolite mi.
If you allow me, the question was here, were you aware that Mr. Rand allegedly was the beneficial owner of BD Agro at the time of the privatization agreement? This answer was in this context. We had meetings exclusively with Mr. Obradovich as the owner of the capital. This answer was given in the context of the question from the title.
Specific statement there that you say that all oral and written communications regarding performance of contractual obligations was conducted with Mr. Obradovich. And my question to you is, did you not have conversations with Mr. Braško and Mr. Markicevic about the performance of contractual obligations?
Imali smo sastanak.
We had meetings with Mr. Braško and Mr. Markicevic, if you mean joint meetings, and those meetings had to do with the proposal to have the agreement assigned. And as for this topic, it was explained to Mr. Braško which contractual obligations had not been met at the time. That is, which contractual obligations were subject to the additional deadline.
Let's look at one such meeting to see exactly what was discussed with Mr. Brashko and Mr. Markicevic. And this is a meeting of the 15th of December 2014, which is Exhibit RE 38. If we could show that to the witness, please. These are the notes of a meeting on the 15th of December 2014. If you look on the first page,
Nem jött. Izvinjam se, samo moment.
I apologize, just a moment.
Izvolite.
Please go ahead.
it says at number 6 that you were present for the meeting. Do you see that?
Tačno je.
Okay.
Yes, that's correct.
In the description of the meeting, and sorry, let me also point out that at number 9 and number 10, Mr. Markicevic and Mr. Brashko are also identified as present. If you look through the 10 people, Mr. Obradovich is not present. Do you see that?
Tako je.
Yes, that's correct.
If you look at the last sentence of the description of the meeting, it says the representative of the entity of privatization have committed to prepare for the next meeting, which is agreed in principle to be held on the 17th of December 2014 in the ministry, the materials on the state of mortgages registered on the property of the entity undergoing privatization as a collateral warranty for the liability of third parties. Now, the privatization agency was asking Mr. Brashko and Mr. Markicevic to prepare materials on the state of mortgages registered on the property for their next meeting with the privatization agency and the ministry, correct?
Tako je.
Yes, that's correct. That's what the last sentence here says. However, in order to understand the context of this description of the topics of the meeting, and the meetings were organized with one aim, and that's upon the proposal to have the agreement assigned. Mr. Broshko introduced himself at the meeting as the executive director of Rand Investments from Canada, as this official note says. And when having agreements assigned, in other cases too, not only in this case, we talked to the buyers and the directors about the situation of the entity undergoing privatization. The assignment agreement deals with the takeover of the rights and obligations from the agreement, given the situation at the time. It was necessary for the assignee to be informed about the mortgages in the company, which was the subject of the breach of 534. The entity undergoing privatization prepared the material, and it's very clear that the future assignee should know about the situation in the entity undergoing privatization because they take over the rights and obligations from the agreement. There is nothing disputable here.
Okay. My question, though, is you are asking the assignee of the agreement to prepare materials on the state of the mortgages on the properties?
Madam, this question, because it is definitely not fair to put that question in that way, having in mind the document that is on the screen. In the documents, it is rightly stated who was requested to deliver the document. So
It
the
says,
council,
yeah, it says the representative of the entity
subject.
of privatization. Can you tell us who you consider to be the representative of the entity of privatization among the 10 people who attended?
Svakako
It was certainly Mr. Markicevic, who was the director of the privatization entity and who was actually preparing also the materials needed for the audit report.
Yes, and it's in the singular representative, and then the verb is in the plural, so have committed, yeah.
That's correct, Madam President, and I will clarify this now with the witness.
Yes, please.
Is your testimony that the only person you thought had a connection, that the only person who could have been a representative of the entity of privatization is Mr. Markicevic?
Tako je.
That is correct.
Sorry for one question in this regard, because here we have the text in its English translation, in which there is apparently a problem because the representative is singular and then have committed is plural. So may I ask what is the Serbian text? What does the Serbian text this? And probably like yesterday, our interpreters can help us.
So in Serbian version, it says representatives of the privatization entity have committed themselves. Representatives it's plural in Serbian.
Thank you.
Thank you.
Thank you, Professor Cohen. That was helpful. So in the original Serbian, it identifies plural representatives. Who else other than Mr. Braško then could have been a representative of the entity of privatization?
Na ovom sastanku
At this meeting, I believe it would be exclusively Mr. Markicevic in his capacity of director of the privatization entity.
That testimony, Mrs. Vučković. At paragraph 8 of your statement, you say something similar. You say, on the meetings with Mr. Igor Markicevic and Mr. Aaron Braško held in the Ministry of Economy on 1 July 2014, 26 October 2014, 3 November 2014, as well as 15 December 2014, we were informed that Mr. Obradovich and Mr. Rand are in some kind of financial relationship, but we were not informed about the details of that relationship. In that paragraph 6 of your statement, the last sentence says, in addition, during 2014 and 2015, I attended meetings with Mr. Braško, who introduced himself as representative of potential assignee of the agreement. You see that?
Izvinjavam se, kog paragrafa? Koje tačke?
6.
Takođe tokom.
Okay.
Vidim.
When was the first time you were introduced to Mr. Braško?
I believe it was already in 2013 when the request to assign the agreement was submitted. I think it was August 1st, 2013, when such a request was submitted to us, and that's when I met him.
To a meeting on the 30th of January 2014. The notes are at Exhibit RE 28.
To je ovo.
Do you have that in front of you now?
Yes.
Okay. The minutes reflect that you were there, correct, at number 5?
Tako je.
It's correct.
So reflect in points 1 and 2 that Mr. Markicevic and Mr. Braško were there, correct?
Tako.
Correct.
The notes say that Mr. Braško is there as the director of Rand Investments, correct?
It is stated here, but I didn't draw up these minutes, but that's what it says here.
The minutes don't mention the word koropi anywhere, do they?
Morala bi da pogledam.
I would need some time to take a look.
U prvoj rečenici, da, kaže povod za sastanak.
Well, sentence 1 says the reason for the meeting was the buyer's request dated 1st August 2013 for issuing the prior approval for assigning the sale purchase agreement of capital. If we take a look carefully at that request, which was submitted by Mr. Obradovich, it says actually that the assignee would be the legal entity Koropi.
In paragraph 6 of your statement is that he introduced himself as the representative of the potential assignee of the agreement, which would be Koropi, correct?
Samo se izvinjam.
Just a second, I'm sorry. Tell me which sentence in paragraph 6 it is exactly.
Last one. Znači, u zadnjoj rečenici moje izjave se kaže tako.
Last sentence of my statement says, in addition, during 2014 and 15, I attended meetings with Mr. Broško, who introduced himself as a representative of potential assignee of the agreement. I have to reiterate, in the request for assignment, it is stated that Koropi would be the assignee. If you will allow me just to add, the one who is authorized to submit an assignment request is exclusively the buyer of capital, which is what happened here. Just like in all other privatization procedures, we've treated this one the same. So the authorized person to submit a request for assignment was exclusively the buyer. In this case, it was Mr. Obradovich, who stated in his request that he would be assigning the agreement to Koropi.
Trying to establish, Mrs. Vučković, is how Mr. Braško introduced himself to you. So let's focus on that in these notes. The notes say, and I quote, Aaron Braško stated that he represented the company which provided funds invested in the entity and that such practice is common in Canada. Braško stated that William Rand was not satisfied with the work and management by the man to whom the job of purchasing the company was entrusted, and that he was interested to finish the assignment as soon as possible. Do you see that?
Jesam.
Okay.
Yes, I see that.
A little bit in how Mr. Braško introduced himself to you. He said he represented the man who provided, past tense, funds invested, past tense, in the entity, which refers to BD Agro, correct?
Tako je.
Correct.
So he's more than just someone who's coming to negotiate as a potential assignee of the agreement, correct?
Ne bi.
I wouldn't phrase it like that. I wouldn't say it's correct. I would say that we already had an assignment request submitted to us, including the name of the legal entity to which the agreement would be assigned. So in this case, for us, these things, we were told that Mr. Rand was not happy with the work of this person, but this was irrelevant to us. From our point of view, the buyer of capital was Mr. Obradovich, so there were no dilemmas concerning that. All correspondence regarding the assignment request within the privatization procedure throughout the validity of the agreement was submitted to us by the buyer, and the buyer was stating therein who the assignee was, and then again, on top of the request, there was the agreement on assignment of rights and obligations arising from the agreement, which also identified the company Koropi as the assignee.
This step by step. The sentence says that Mr. Broshko told you that Mr. Rand was not satisfied with the work and management by the man to whom the job of purchasing the company was entrusted. Or to whom the business of purchasing the company was entrusted, and that he was that he was interested to finish the assignment as soon as possible. Now, the man you knew was a reference to Mr. Obradovich, correct?
Well, the only thing that was clear to us was that Mr. Obradovich was the buyer of capital. He was presented as the buyer of capital, and he fully controlled the privatization entity. There was no doubt about the existence, possible existence of another owner apart from Mr. Obradovich. All correspondence, all communication in verbal form, everything regarding the performance of obligations was happened between us, the privatization agency, and Mr. Obradovich as the owner of capital.
Obradovich was not present for this meeting, correct?
That's clear from the minutes, yes.
But Mr. Markicevic, who was the director of BD Agro, was present at the meeting, and he was part of the management of BD Agro, correct?
He was the director of the privatization entity, and he did attend the meeting.
Did you find it odd that Mr. Broshko was stating his Mr. Rand's dissatisfaction with the management of BD Agro while one of the members of the management of BD Agro was sitting next to him in the meeting?
It could have seemed to me, I cannot really remember the exact moment what I was thinking at that moment, but it could have been strange to me back then. However, it was not relevant to us, it was not significant to us. I have to reiterate, we kept in mind that Mr. Obradovich was the buyer of capital, and that all correspondence in writing and all communication happened with Mr. Obradovich. If you will allow me to add, there was no moment when we had any written or verbal address by Mr. Rand. Throughout the validity of the period, throughout the term of the period from 2005 to 2000, when the agreement was concluded, until 2015 when it was terminated, Mr. Rand never addressed us.
Again, this is paragraph 8. We were informed that Mr. Obradovich and Mr. Rand are in some kind of financial relationship, but we were not informed about the details of that relationship. And I'll take you back now to the notes of the 30 January meeting to see what exactly you were told about that relationship. Again, you were told expressly that the funds invested in the entity were provided by Mr. Rand's company, correct?
correct.
Now, if you were told that Mr. Rand was simply a lender, then you would have understood the nature of the relationship between the two of them, correct?
Ne bih se složila.
I would disagree, actually, with this statement, given the following. Yes, it is correct that we were told that there was some type of financial relation. As it's stated here in the minutes, let me find it. It says here that his funds were used to fund the entire privatization process. They might have had some type of a financial relation, but again, it's completely insignificant for the privatization agreement, which states clearly that the buyer of capital is Mr. Obradovich. Now, whether there was some form of a relation between Mr. Obradovich, Mr. Rand, or another third party, it's an inter partes relation which is not relevant for the privatization agreement.
About the nature of their relationship. Mr. Broshko told you, according to these notes, that Mr. Rand was not satisfied with the work and management by the man to whom the business of purchasing the company was entrusted. And I'm going to focus on that word entrusted. In Serbian, in the original text, the word used is povereno. What did it mean to you when Mr. Broshko said that Mr. Rand had entrusted Mr. Obradovich with purchasing the company?
U postupku
Well, in the privatization procedure, in accordance with regulations governing privatization, which were valid throughout this privatization procedure, even before the agreement was concluded and after the termination of agreement, there was no possibility to entrust these transactions related to purchase of companies. The buyer of capital, according to the law, is the person with whom the agreement was concluded. According to our legal system, there was no possibility to recognize third person in such transactions. There were no entrusted transactions according to the legislation.
Opinion on whether you think it was valid or not. I'm just trying to establish what you understood about the nature of the relationship between the two of them. And my question to you is, what does it mean to you when Mr. Broshko says that Mr. Rand entrusted Mr. Obradovich with purchasing BD Agro?
I'm sorry to all of you, to the claimants and to the arbitrators, but I have to say it was completely irrelevant for us. It is the relation that the buyer has with somebody else. It was completely irrelevant for the privatization procedure. Throughout the term of the agreement, Mr. Obradovich represented himself and behaved as the capital buyer. I'm sorry for having to repeat this, but all correspondence was conducted with Mr. Obradovich exclusively with reference to the performance of obligations.
He had absolute control over the capital. And I apologize for making this personal digression. If I were the beneficial owner, as for you are saying, I would, at least during the term of this agreement, and allow me to say that this agreement lasted for quite a long, from 2005 to 2015. During this time, I would have at least once addressed the privatization agency and asked them what was going on. So I repeat, there was no oral or written communication or any contact by Mr. Rand with privatization agency during the period when control was conducted. We had not had such communication. It was not recorded at all.
Earlier, you said that the practice of entrusting someone to purchase a company was not recognized under Serbian law, correct?
Yes, correct. The privatization law does not recognize this.
So when, if you look at the notes again, it says that Mr. Broshko said that such practice is common in Canada. You understood that what he meant was the practice of purchasing, entrusting someone to purchase a company on their behalf, correct?
What I understood, and at both the beginning and the end of this meeting, and during the meeting, and during the term of this agreement, was that Mr. Obradovich was the sole owner of the company. And for us, it was totally irrelevant as to whether the buyer had any financial relationships with any third party. He could have had such relationship. But for privatization, this was not possible. In the privatization process, I apologize, in this process, this was not possible.
Ti smo imali
Nor did we have any case that we had a third party which acted as a party that the privatization agency concluded an agreement with.
I'd like to take you to, staying on this topic, but on a different document. This is Exhibit CE 317. Do you have the document?
nisam čula CE
3,
Can you repeat the number?
317.
Gdje je ovdje datum? Nema datuma, samo pečat ovaj.
for the interpreters.
That's correct.
If you look at the document, it purports to be a letter from the privatization agency dated 21 August 2014 to Mr. Markicevic, correct?
Yes, correct.
And if you, I'd ask you to go look at the original Serbian version of this document. Is that, did that document go out with your authorization?
Jeste.
Yes. So here it says that the director of the center is Ms. Julijana Vučković. I was not the one who signed it. Here it says for the director. So this was signed by my assistant, the director of the center. Probably I was absent at the time.
Look at the bottom of the first page in English, which begins, upon initiation of procedure of supervision. If you could,
Vidim.
yes.
I can see that.
The meeting was held on the 30th of January 2014 in the privatization agency, which you attended in capacity of the director of the subject, along with the representatives of the privatization agency, Aaron Broshko, director of Rand Investments, and Milan Kostic. Do you see that?
Vidim.
Yes, I can see that.
2 paragraphs later, the letter summarizes what was discussed at the meeting. At the meeting, you introduced Aaron Broshko, director of Rand Investments, Vancouver, Canada, company owned by William Rand, and you stated that his means were used to finance the entire process of privatization of BD Agro do Banovci. Do you see that?
Vidim.
Yes.
The privatization agency was aware, as a result of that 30th of January 2014 meeting, that it was Mr. Rand's money that had been used to finance the entire process of privatization of BD Agro, correct?
No, I do not agree with your statement. In the paragraph that you are referencing, it says, at the meeting, to the participants, you introduced Mr. Erin Breshko. So Mr. Markicevic introduced Mr. Erin Breshko as the director of Rand Investment, the company owned by William Rand, and you are saying that his funds were used to finance the entire privatization process. We are here quoting the words of another person. This is not saying that we believe what it says here was true.
Back to paragraph 6 of your witness statement, the last sentence. You're saying in that sentence that Mr. Broshko introduced himself as the representative of the potential assignee, and in this letter that we're looking at, you're now saying that Mr. Broshko was introduced to you as the director of the company owned by William Rand, and that his means were used to finance the entire process of privatization of BD Agro, correct?
That's what it says here. Mr. Broshko, as you can see for yourselves, at these meetings that you are focusing on, he introduced himself in different ways. And this is what these texts say. This is not a confirmation that the agency felt this was true. These are statements that were presented to us at the meetings we held. And there is a huge difference between the two.
I'm just trying to establish what you knew or what had been represented to you. That's all. If we go to the next paragraph.
I
think it is more precise to say what was presented to us, but we did not know this because, I repeat, not a single document said this. There was no representation to us in either oral or written form throughout the term of this agreement. And I repeat, this is a very long time. We never had the official address during the term of the privatization agreement.
Next paragraph in the letter that went out under your authorization to Mr. Markicevic, your own letter says or uses the word entrusted in recounting that Mr. Broshko said.
I apologize, I can't find it. Now I have it. You can go on, thank you.
Says that what Mr. Broshko said was that William Rand was not pleased by the work and management of the person they had entrusted with the purchase of the company, and that he was interested in fast completion of the assignment process. Again, your letter used the word entrusted as to how Mr. Broshko had introduced himself to you, correct?
Unfortunately, I'll have to repeat again. These are the words of a third party, and the words are repeated here in the same way in which they were presented to the agency. We never received any evidence on what this text is saying. As a result, we could not focus our attention to this in the way in which you want me now to confirm this.
Which at the outset of my questioning, I asked you whether you could recall meeting with Mr. Obradovich in 2014 and 2015 and about assignment of the privatization agreement, and you said you didn't recall having such a meeting with him. Correct?
I think I don't remember. The lady said, I think that it was not, but that was not absolutely clear. Can you ask the lady to repeat her sentence for clarity, please?
Your answer, the interpreters did not hear your answer. Could you repeat your answer again?
Maybe you... could you please repeat the question? Thank you.
You stated at the beginning of your testimony that you did not recall meeting with Mr. Obradovich about assignment of the privatization agreement in 2014 and 2015, correct?
Da,
Yes, I said that. Unfortunately, I'm sorry I can't respond to this question precisely, but I can't remember. I think no, because we had a large number of meetings on BD Agro Dobanovci with Mr. Obradovich. The number must have been more than 10. And I feel free to say even more. But during this time that you're asking about, I can't say we had those meetings.
For your testimony today, have you seen any notes of any meetings that, with Mr. Obradovich in 2014 and 2015 about assignment of the privatization agreement?
I can't remember, as I explained.
The reasons that you may not have met with Mr. Obradovich in 2014 and 2015 about assignment of the purchase agreement, that the privatization agency had been informed that Mr. Rand had financed the privatization, was dissatisfied with Mr. Obradovich's management, and therefore he no longer needed to be present for any of these meetings.
I apologize to Madam President and members of the panel. Let me repeat. This had no relevance at all to the request by Mr. Obradovich for assignment of the agreement.
Just draw your attention to paragraph 8 again of your witness statement. You identify meetings with Mr. Markicevic and Mr. Brashko on the 1st of July 2014, the 26th of October 2014, 3rd of November 2014, and the 15th of December 2014. Do you see that?
vidim.
Yes, I can see.
Is there a reason you did not disclose the 30 January 2014 meeting with Mr. Brashko and Mr. Markicevic?
No, not really. I think these meetings were mentioned by the claimants, and I recorded them here as such.
Okay. Thank you. I'm going to turn to a different topic now, Mrs. Vučković. If we could show Exhibit CE 30, please.
Izvinjam se, samo da nađem.
Please allow me some time to find it.
Da, pronašla sam.
Have it. You can go on, thank you.
What is this document?
Izveštaj.
It is the report on control.
Okay. If we turn to page 2 of the document. First, let me ask you, did you have any role in the preparation of this document?
Ne, kao što je
No. As it was explained at the beginning of my statement, the Center for Control was organized in such a manner that it was headed by the director and the deputy, and there were also assistants and associates who conducted the direct control of the documentation that was submitted on the privatization entity and the control of the documentation that was submitted by the buyer. So I never was directly involved in the control itself.
Okay. If you look at the first paragraph on page 2 under introductory remarks, the first 2 paragraphs. If you could read them to yourself.
Dobro.
Okay, I've read them.
Now, the term of the agreement, right, was set to expire on October 4th, 2010. Do you see that?
Vidim.
Yes, I can see that.
Can you explain to the tribunal why the term was set to expire on the 4th of October 2010?
All agreements on the sale of capital, including the agreement on the sale of BD Agro Dobanovci Capital, entailed certain contractual obligations, and those obligations included the way in which the agreement was to be enforced and the terms. And if the buyer was acting bona fide and if he was performing all his obligations within the terms set by the agreement and in the manner set by the agreement, and bearing in mind that the buyer of the capital is a physical person, could pay the purchase price in 6 separate installments, this was the longest contractual obligations. Having in mind, however, and I need to emphasize this, on condition that the buyer was acting bona fide in performing his contractual obligations. All other obligations were set for 2 years. 534 had the duration during the term of the agreement, and the second one until the purchase of the payment of the purchase price. Now, the agreement was signed on the 24th of October 2005. The first installment was paid in 2005. Unfortunately, the last installment, the 6th installment, was not paid on the 4th of October 2010. And had the 6th installment been paid on the 4th of October 2010, or until the period before the December 2010, yes, that would have been the longest term from the agreement. Given that in a situation of BD Agro Dobanovci, the breach of the contractual obligation occurred before the payment of the purchase price, so the obligation was breached. And this breach happened before the payment of the purchase price. So the buyer was delayed, and the installment was paid on the 8th of April of 2011, if I remember well. So practically, the failure by the buyer was what prolonged the contractual obligation.
But that, what you just added there, that about the breach by the buyer on other provisions isn't stated in these introductory remarks that are in front of you, correct? It just says that the term would be extended so that he could make the 6th and final payment, correct?
Tako je.
Yes, that is correct. Taking into account the provisions of the agreement and the provisions of the law, if the buyer does not perform his contractual obligation, the privatization agency has the duty to grant the buyer an extended deadline within which he can remedy the breach. So by giving this extended deadline, and I repeat, for the violation that occurred before the payment of the 6th installment of the purchase price, so before the deadline which was set for a bona fide buyer. But then this extended deadline was granted, and during this deadline, the buyer was supposed to remedy the breach which occurred before the payment of the purchase price. And please, let me clarify this. The privatization agency acted in this way from the conclusion of the agreement until the termination of the agreement. So the same practice has been in place throughout this time because this privatization has not ended yet.
We'll get to some of those issues a bit later on, but for now, let's stay with this document, and if we could look at page 8, please.
Ja se izvinjam, samo nisu obeležene stranice, pa ću vas...
These pages are not do not have page numbers, so could you please help me find it?
Hvala.
Thank you.
Hvala, našla sam.
Thank you, I have found it.
The paragraph, the second paragraph under the bolded paragraph that's at 5.3.1. The paragraph begins, the ban on disposal of shares expired on October 4, 2007.
Dobro.
Okay.
But given that the contractual provision and the share pledge agreement stipulate a pledge in favor of the agency until payment of the complete sale and purchase price, and then it goes on, the buyer was notified via a letter announcing the control to ensure the excerpt from the CSD and CH on the state of his proprietary and pledge account on the day of the scheduled control. The pledge on shares was only supposed to be in place until the complete sale and purchase price had been paid. Is that correct?
Tako je.
Yes, that's correct.
Nesporno to stoji.
That's clearly stated in our agreement.
And if we go to page 21 of this document, which discusses section 533. I'm not going to read the whole paragraph out loud to spare the interpreters, but if you could please just read to yourself the paragraph that begins, we highlight that over the course of 2007.
Dobro.
So the agency was aware that the reason that BD Agro had gone over the 30% threshold in 533 was because of the order of the Ministry of Agriculture to put down livestock that had been infected, correct?
Samo se izvinjam.
I apologize.
Bilo je to...
It was concluded in the 2011 control, but if you look at the previous pages of this report, you will see in the introductory remarks that the performance of obligation was conformed, was checked from 8th of June 2010 till 17th January 2011. So the overall percentage wouldn't have reflected what you're discussing here. This was only for the period of this control. This is not a report regarding the period from the conclusion of the agreement till the payment of the purchase price. This is only one of the segments, and it's clearly stated in this report.
Znači, uvodne napomene.
So in the introductory remarks, in the second sentence, the period of control was 18th of June 2010 to 17th January 2011. That is the period since the previous control.
The agency then sent a notice to Mr. Obradovich about certain steps he had to take to be in compliance with the agreement, correct? And I can show you the document. That's Exhibit CE 31.
Tako je.
Yes, that's correct.
2 in English. The paragraph above the bullet points on page 3. If we scroll up, I just want her to be able to find it. It says, having in mind the above stated, in accordance with Article 41A of the law on privatization, the buyer is given an additionally granted term of 60 days from the day of the receipt of the decision for fulfillment of obligations referred to in items 533 and 534 of the agreement. Now, the only reason that he could, meaning Mr. Obradovich, could have been or not have fulfilled 533 on February 25th, 2011, is if you include the cows that had been put down as a result of the order of the ministry, correct?
Tačno je da je nakon
It is correct that upon the control performed for a certain period, an additional deadline was given, and you can see in the notice that this included the need for the buyer to act on 533 and 534, which includes much more than disposal of assets. In the control period, already in 2009, we established a breach of 534 by the buyer, and we granted 13 additional deadlines until the termination of the agreement and 7 deadlines approximately regarding disposal of assets. In 2011, I can claim responsibly, we didn't know with certainty that this was the only disposal of assets by the privatization entity, because we got some new information in the control. We got the information on disposal of land, and the buyer, that is the entity, did not submit documentation on this. The control also found that part of the assets had been given as a gift. We also got the information that a part of the assets had been donated. We got the information that assets had been sold and the price had never been paid. So we asked for the percentage of disposal to be confirmed. Annually, this has to do with the ban concerning a level of 10% and globally, and that's 30%.
Okay, if you go to the bullets, the bullet points, next. Those were all of the steps that Mr. Obradovich needed to fulfill in order to be in compliance with the agreement according to the privatization agency's perspective, correct?
upravo
Yes, precisely.
And it included deleting pledges deleting encumbrances on the property and returning Inex and Crveni Signal returning loans that had been given to them, correct?
Among other things, to delete all encumbrances and return all the funds and loans. At the moment, I cannot recall what exactly this control found, whether it was only Crveni Signal or also Inex Nova Varoš. You need to remember that in our controls, we learned things, but later on, the audit reports found that the buyer had given many more loans than these mentioned here. There was also a large number of mortgages registered that the buyer deleted over time. Those are breaches of 534, meaning that the privatization entity was not the user of those funds. So this doesn't only concern the loans to Crveni Signal Inex Nova Varoš. There were many loans that were not repaid, and that during the validity of the agreement were repaid. So the buyer was supposed to act in terms of repaying the loans and deleting the mortgages as the other part of the obligation under 534.
That the agency did not tell Mr. Obradovich that if Inex and Crveni Signal simply repaid the money, the privatization agency would not terminate the agreement, correct?
I will not agree with you there. I will not agree at all. It says clearly here that all the loans the privatization entity had given to third parties were to be repaid. It was very clear, all the more so because Mr. Obradovich bought several companies in the privatization process. I don't remember exactly. I think 7 or 8. I apologize to the tribunal for not knowing the exact number, but it was not lower than 7, certainly. And in one of those companies, and that's Pikpeshte, and I remember that very well, we had the same situation. A third party was the user of a loan that it concluded with the bank, and Pikpeshte registered a mortgage as a privatization entity. And under an additional deadline, Mr. Obradovich lifted this mortgage. Also, during the validity of the agreement, there were a rather large number of loans that Mr. Obradovich repaid. So Mr. Obradovich knew very well what he was supposed to do. All the more so, I need to add that with Mr. Obradovich as the buyer of the capital, with the director of the privatization entity, with the auditors, with the representatives of the BD Agro Technical Services on the one hand, and with the representatives of the privatization agency, and with the representatives of the technical services, meetings were held where the buyer was clearly pointed to the breaches of contractual obligations. And we understood this so, and I'm 100% sure that the buyer knew very well what he was supposed to do. And a confirmation of this are the audit reports where he spoke all the time about the mortgages and the loans. So I really believe that there is no dilemma if you look at the facts. All the more so when addressing us, the buyer was saying that he would repay the loans of Crveni Signal and Inex Nova Varoš. So those were the grounds for which the agreement was terminated in the end. In one letter, he even says, please grant me an additional deadline to do this. Let us remember, 13 additional deadlines were given to the buyer for the implementation of this contractual obligation. I think this is more than enough. And all this was done with the aim of keeping the agreement in force. This was what led us in the entire privatization process, not only with BD Agro Dobanovci, but all the agreements concluded in that process.
Understood each other with the question. I appreciate the long answer. So I'm going to ask it one more time, but if you could keep it short. It's probably my fault for asking it poorly. But let's
Ali mislim da je bilo korisno.
I think this was useful, though.
Ask a short question and hopefully get a short answer. This letter was supposed to tell Mr. Obradovich that he was supposed to repay the loans from Inex and Crveni Signal and do more than that, correct?
U ovom dopisu
This letter says, I clearly gave you an answer, that all the loans that the privatization entity gave to third parties from the loans secured by encumbrances on the assets. During the privatization process, there were more such cases, not only Crveni Signal and Inex. And Mr. Obradovich deleted some, but we were stuck at these of Crveni Signal and Inex Nova Varoš.
Thank you. Let me turn to a different part of your witness statement. And this is paragraph 14, I believe. Yes. Here you discuss the role of the Ministry of Economy. And the first sentence says, in May 2012, the agency addressed the Ministry of Economy and Regional Development concerning Mr. Obradovich's appeal against actions of the agency. What appeals of Mr. Obradovich are you referring to there?
na jednom od sastanaka
At one of the meetings that had been requested by Mr. Obradovich, it was organized by the Ministry of Economy. There were such meetings in late 2011 and early 2012, precisely at the initiative of Mr. Obradovich, who said that he had done everything and it was not founded for the agency to ask for anything because he believed he had met his obligations. And that was at a time when there were quite a few breaches of contractual obligations. He sent a complaint to the ministry, but it's interesting that even in this so-called complaint, he mentioned that he had not repaid the loans, but that he would repay them.
That paragraph goes on to say, we received a short answer from the ministry stating that they consider the termination of the privatization agreement is not economically justified. The ministry did not further elaborate its opinion in order to deal with the issue of application of Article 41A of the law on privatization. That is, whether the agreement was violated and whether the legal reasons for termination of the agreement came into effect. Now, why did the Commission decide to seek the opinion of the ministry?
upravo iz razloga koje sam napomenula.
Well, the reasons I've mentioned already. The privatization agency did not decide on its own did not just decide just like that to ask the opinion of the ministry. It was because Mr. Obradovich mentioned briefly at the meeting at the ministry that he intends to file a complaint. So we've addressed the ministry because we wanted to get the opinion of the ministry about that situation, because the actions, we wanted to hear from them whether they thought that we were doing the right thing and acting properly. The ministry said in their response, they actually covered the response from an economic point of view, which is not what they were asked for. We were not deciding and taking actions on the basis of economic justification. We were taking actions on the basis of very clearly stipulated obligations from the agreement which we were controlling. And in cases where such obligations were violated, we had to take some actions. So their opinion actually did not contain the legal aspect, which was the decisive factor for us to take such a decision.
You say you sought the ministry's opinion, but if we could look at Exhibit CE 33, please.
Esto. Dobro.
This is the letter from the ministry to the privatization agency. And in the first paragraph, it says, in regards to your letter dated May 10, 2012, regarding the case of privatization of AD/BD Agro Dobanovci, requesting further instructions and directions for additional actions. Do you see that? The privatization agency was asking for instructions from the ministry, correct?
That's what it says here, and yes, that's what we were asking for.
The ministry there explains what materials it reviewed and then concluded that there was no economic justification for termination, correct?
It's correct. The ministry says it's not economically justified to terminate it.
Paragraph 14 of your statement, you say that the ministry did not elaborate on its opinion that termination of the agreement was not economically justified. Do you see that?
I can see that, yes.
If we go back to the ministry's letter, there are 4 bullet points there explaining why they don't believe it's economically justified. Why is it your testimony that the ministry did not elaborate on its opinion?
It is because the ministry only covered one part, the part related to economic aspect, while disregarding the legal aspect. And the legal aspect is the basis for our decision. We are terminating the agreement not because something is economically justified or not. We do not even have such authorizations. We will be terminating only in the case if a contractual obligation has not been performed.
What you intended to say was not that the ministry did not elaborate on its opinion that it was not economically justified, but that the ministry did not provide a legal analysis on termination, correct?
Yes, just as we said, they did not provide a detailed explanation. They did not elaborate on the legal analysis, and that's the first thing that we need, the legal analysis.
Then the ministry ultimately did seek a legal analysis from the law firm of Obradovich and Ratkovich, correct? Sorry, let me correct that. The agency did seek a legal analysis from the law firm of Obradovich and Ratkovich, correct?
Yes.
It's correct.
And you discussed that at paragraph 20 of your statement. You say that the agency did not accept the interpretation expressed in the opinion of the law office of Obradovich and Ratkovic from 2013. The agency did not agree with such legal interpretation, and as I already stated, it acted in a different matter in privatizations when it comes to termination due to reasons which are not stated in the agreement, but they are in the law, as well as when it comes to termination after payment of the purchase price. The agency requested the opinion of the law firm, correct?
Tačno.
Correct.
And the agency sought that opinion in order to establish whether there was a legal basis for the agency to terminate the privatization agreement, correct?
Izvinjam se, samo uvijek.
Just a second, I'm trying to find that. Where is that stated?
Document. I'm saying you had approached the law firm of Obradovich and Ratkovic to obtain an opinion on whether there was a legal basis to terminate the privatization agreement, correct?
Yes, we've addressed, that is the privatization agency, just as you said, we've addressed the ministry and them, keeping in mind that the buyer kept emphasizing and asking himself for the opinion of the ministry. The buyer wanted to get a confirmation that he had performed all the obligations at a time when there were clear violations of contractual obligations. So this law office, which represented the agency in all disputes against third parties, was addressed to get the opinion, as we said. The privatization agency disagreed with the opinion, seeing that it was, first of all, contrary to all of the previous actions taken and to all of the future ones. It's very interesting to note that the same law office conducted a dispute in which they took an entirely different opinion to this one. They had the same opinion that we had, and that is that the agreement may be terminated after the payment of the purchase price under the condition that a violation of contractual obligation has been established prior to that. Additionally, that an agreement may be terminated even though the termination reason is not stated in the agreement itself, but it is stated in the law. And such a position is contained in many final decisions of our courts, which have stipulated very clearly that if the agreement does not state a reason to terminate that agreement, but it is stated in the law, then the agreement will be terminated under the law. So, as I said, these are final court decisions stipulating that it is so. So those were very clear reasons for not accepting that position of the law firm. The agency acted like that before and after in other cases. So why would we make an exception when it comes to this case? There were no reasons to do that.
Said that the agency disagreed with the law firm's opinion, and I believe you said that the law firm itself took a contrary position in a different matter. Did you approach the law firm?
Tako je.
Yes, that's correct.
Did you approach the law firm after this opinion and say and raise any of these issues with them?
Pa ne, nismo imali.
No. The Center for Control or the Commission did not do that, but the privatization agency did communicate permanently with this law firm. So I believe that they probably did share their disagreement with their opinion. For us, it was important that we kept having the same points of view when we are treating all different privatization entities, because had we taken differing point of view in this case, it would be a first step towards a completely different practice and towards allowing buyers to fail to act upon their contractual obligations.
Which there were, in fact, cases prior to the BD Agro case where the agency had lifted the pledge on shares even though the agency did not believe that the buyer had completed all of its obligations under the agreement. Correct?
Ja se ne sjećam.
I do not remember such cases. I truly do not remember any situation where the agency would remove, that is, lift the pledge without the buyer performing on his obligations.
Your testimony now is you're not aware of any case where the buyer had made the final payment, so the agency lifted the pledge, even though there had been, in the agency's view, some obligations that had not yet been fulfilled. Correct?
Ni-
I am not claiming it is so. I am saying I cannot remember of any such a case, so it would be incorrect.
Point a bit in a little bit. I'm going to stay on this topic for a second. If we go to Exhibit CE 43, please. This is a letter from the agency to the Ombudsman dated the 30th of October, sorry, dated the 14th of November, 2014. Do you see that?
Vidim.
Yes, I do.
Did you participate in any discussions of the agency about how to respond to the Ombudsman's inquiry?
Učest-
I did take part when it comes to discussions regarding the performance of contractual obligations, only as regards that part.
Well, if we look at this letter, it says that the first paragraph says that the letter, in a letter submitted to the Privatization Agency on October 31, 2014, you asked the agency to provide the reasons why it did not terminate the agreement on the sale of capital of BD Agro. Do you see that?
Vidim.
Yes, I do.
Then in the next paragraph, it says there are several reasons why the agency did not render a decision on termination of the agreement. And the first bullet point there is unresolved legal issues regarding fulfillment of contractual obligations. Do you see that?
Kako?
Yes, I do.
The reason there were unresolved legal issues was the agency was in possession of an opinion from the ministry saying there was no economic justification, and an opinion from the law firm of Obradovich and Ratkovich saying there was no legal justification for termination, correct?
Tačno.
It is correct. It's stated that way in this letter.
Go to page 3 of the document in English. There's a discussion about the unresolved legal issues. I'll give you a minute to take a look at it, so I don't have to read it all out loud.
Ćete mi samo ukazati koji je to deo?
Can you please tell me which paragraph that is specifically? Oh, I'm sorry. I was shown, but maybe for the sake of interpreters, if you could share, we are struggling here to find it, please. The exact paragraph. Dakle,
Gde je to?
okay, where is that paragraph? Trying to find it.
Našla sam, hvala vam.
I found it, thank you.
Pročitala sam.
Read it.
Was informing the ombudsman that it did not terminate the agreement because BD Agro's case was a factually and legally complex situation, correct?
It is correct.
It was informing the ombudsman there was a danger that the buyer would sue and that there would be serious consequences for the state budget of Serbia, correct?
That is what it says here.
That as a result of this, the decision was made not to take into consideration the case of BD Agro Dobanovci before the receipt of the response of the ministry. That is the conclusion of the government, correct?
Vi ste,
Well, at the beginning you said that the agency has stated that there are several reasons on account of which it has not taken this decision, and then you mentioned unresolved legal issue. We did not get instructions from the line ministry, the point of view of the Ministry of Economy that it's not economically justified, the debatable legal basis, but you did not mention the fact that the procedural oversight of the work of the agency has been initiated, but it hasn't been terminated. Now, the Ombudsman has addressed us on the basis of well, a request they received from the Association of Employers. And in this case, we truly paid a lot of attention, and in a bona fide way, we were taking into consideration all aspects of the case, making sure we don't violate any contractual obligations and to give a chance to the buyer to perform on the obligations and to have a successful privatization case. Our interest was to achieve economic development and growth and social stability, given the number of employees, because all of these agreements, privatization agreements, regardless of whether they concerned sale of capital or sale of assets, they had an economic and social nature. Therefore,
what we are saying to the Ombudsman is that let me remind you that in 2012, the position of the agency that the conditions for the termination of the agreement were in place. But we were trying again to resolve these issues so as not to cause harm to the buyer itself. So all of the issues listed here were subject of a thorough discussion by all the members of the Commission. These same issues were also discussed with the buyer, the representative of the technical services, and with auditors. So the control of contractual obligations also had a preventive nature, namely to help the buyer perform on his obligations. So this is absolutely clear what the privatization agency was explaining to the ombudsman. We were actually telling him what issues had been discussed, given that this is the letter of the 14th of November 2014 and the supervision procedure over the legality of the acts and the process had already been initiated in December 2013. So we waited for the report following the supervision procedure. That is the essence of the letter sent to the Ombudsman.
Okay, let me ask you this. If you would look at the third paragraph from the end of the document and just ask you if you agree with what is stated there.
Mislite na stav u skladu s tim?
So are you asking about the paragraph saying, in line with this, the decision was made not to take into consideration the case of BD Agro before the receipt of the response of the ministry? That is the conclusion of the government. Is that the paragraph you're referring to?
That decision was made for those reasons, as stated in that paragraph.
So the position was not to discuss this until the response from the ministry was received. The reference here was to the report on the supervision procedure. For us, what was important was the supervision conducted by the ministry.
Thank you, Mrs. Vučković. Madam President, I know we have to take a break, and this would be a good opportunity for a break.
Absolutely. And you will tell me after the break how much longer your cross-examination will be, I assume.
Yes, Madam President.
Good. Then we can take a 15-minute break. I've noted last night, looking at the time used, that actually there's not that much party time used every day. So maybe I'm giving too long breaks. And but I think we have a good rhythm, so it's fine. I don't want to shorten the breaks, but I'm just flagging this because if you insist on using your entire time allocated over the entire hearing, the days towards the end will become longer. So we just have to know this. Unless you tell me you will absolutely need the entirety of your time, we can continue as we do now. Otherwise, it's better to accelerate and not be too tight at the end. So we are really in your hands, but I'm just raising this.
Thank you, Madam President. We'll discuss internally with our team.
Yes, we will also discuss it. Thanks.
Good. Fine. And then I should say to you, Mrs. Vukovic, that during the break you should please not speak to anyone. Thank you.
Hvala.
Thank you.
Let's take 15 minutes now. Should we close the door, or do you prefer the door open? Ah, Marissa is not here. Oh, sorry. There she is. Good, I was just told that the next witness, Mr. Setkovic, will also testify in Serbian. Is that what is agreed?
Yes, Madam President. Mr. Cvetkovic said that he will testify in English, but
Yes.
he is more comfortable with Serbian, and the other side agreed. We informed them before now, and I asked Marissa if she could inform the translators, the interpreters.
I think everybody informed now.
And I'm thankful for the understanding of the other side. Thank you.
Good. Are we ready to continue?
Yes, Madam President.
Please.
I hope to finish before noon.
That would be perfect.
Thank you. Welcome back, Mrs. Vučković.
Također.
We,
Thank you.
with the letter to the ombudsman, which concluded that the agency was waiting for the receipt of a response from the ministry. And in your witness statement at paragraph 16, you note that a letter and report of the ministry was received on the 7th of April 2015, where the agency granted, after which the agency granted a deadline to the buyer. Correct?
Yes, correct.
So the response that the agency was waiting for from the ministry is the response that came on the 7th of April 2015, correct?
Yes, it arrived in April 2015, correct.
Okay. I'd like to then turn to the discussion at the meeting of the commission on the 23rd of April 2015, which is a CE 768. Have you had a chance to review this transcript?
Yes.
Yes, I have.
So as you know, I'm going to ask you a few questions about the transcript. If we turn to page 2 in English. The first paragraph I'd like to start with starts with first of these provisions, 533, and this is now you speaking. You said first of these provisions, 533, was prescribed as basis for termination of the agreement, and the other one, which refers to pledges in accordance with the agreement, was not prescribed as a basis for termination of the agreement, although Article 41A of the Law on Privatization, which is applicable on these agreements, prescribes that an agreement may be terminated in case of explicitly listed violations of contractual obligations. And then the last item of the article, it prescribes it may be terminated in other cases as prescribed in the agreement. You see that?
Da.
Yes.
Okay. And a little bit further on, you said, the buyer then submitted certain proofs wherein the auditor confirmed that it fulfilled, that is, it acted in accordance with 533. You see that?
Da.
Yes,
Your position at the meeting was that the agency had already received confirmation from the auditor that the obligations under 533 had been fulfilled, correct?
Tako je.
correct.
Okay. And then, towards the bottom of that page, it says, bearing in mind that all other obligations, sorry, let me start again. Immediately after that sentence, it discusses a remaining obligation under 534. And then you said, bearing in mind that all other obligations were fulfilled at the time, the Commission took a standpoint to ask for the opinion of the competent ministry, since this was the buyer's only remaining obligation. Correct?
Yes, that's what it says here.
Okay. And then it goes on to discuss that request to the ministry from 2012. And my first question to you is, as I understand your words at the time, back in 2012, the agency was already aware that the only remaining obligation was 533 before it asked for an opinion of the ministry, correct?
I apologize, I could not follow you. So, we are talking about the transcript for the meeting held on the 23rd of April 2015. And you mentioned 2012, I think, if I correctly got your words.
Earlier this morning, we discussed that your testimony was that Mr. Obradovich had complained and appealed because he said he had fulfilled his obligations, and as a result of that, the agency sought the opinion of the ministry, correct?
Yes, correct.
And that occurred in 2012, correct?
Yes.
Okay. So if you read the paragraph in the transcript, I believe there you were discussing that situation, and you said, bearing in mind that all other obligations were fulfilled at the time, the Commission took a standpoint to ask for the opinion of the competent ministry, since this was the buyer's only remaining obligation, whereas the buyer objected and pointed out that it fulfilled all of the obligations, and that we no longer have grounds to take actions against the buyer after payment of the purchase price. These were the reasons why we decided to address the competent ministry, and the competent ministry in June of 2013, I think, on the 5th of June 2012, delivered its opinion that it would not be expedient to terminate the agreement on sale of capital. You see that?
I can't see the last part of your sentence here in writing.
Da.
Yes?
My question to you was, what you were saying there was, back in 2012, the buyer had fulfilled all obligations under the agreement except for 534 in the ministry's view. That's what the ministry's position was. Sorry, the agency's position. I apologize.
Agencije.
Yes, the agency's position. So here we don't say that this is agency's position. Here we say that the auditor confirmed that the auditor was saying that the buyer had performed on his obligations from 533. This was not the position of the privatization agency. Here we are paraphrasing what the auditor was saying in his report. And the auditor had stated clearly in his report that the obligations from 533 had been fulfilled. But the fact that at the annual basis, they hadn't disposed with more than 10% and that they hadn't disposed of over 30% before the payment of the purchase price. In this case, it would have been considered that he had complied with his obligations. Allow me to remind you that the auditor report in 2011 and 2012 did not include a precise statement anywhere that not over 30% had been disposed of. The task of the auditor in all auditors' reports, which is clearly stated in introduction, is that the task of the auditor is to clearly and unequivocally, we're using these phrases unequivocally, to confirm the performance of the obligation, which includes the threshold of 10% and threshold of 30%. Unfortunately, the auditor in 2011, if you look at his first report, the first that he submitted and the last one, there he mentions the 10% threshold only and doesn't say anything about the 30% threshold. In mid-2011, he says,
relatively clear. When I read in this report, bearing in mind that all other obligations were fulfilled at the time, the Commission took a standpoint to ask for the opinion of the competent ministry. Who is saying this? Is it the auditors of BD Agro, or is it the Commission?
Indirectly, it can be concluded from the opinion of the auditor. So we are practically retelling the opinion of the auditor with respect to 2012 and 2013.
That when we come to it.
Thank you, Madam President. The other question I have on this is, you were also telling the Commission that the buyer, this is now, you're discussing what happened in 2012, and you say the buyer objected and pointed out that it fulfilled all of its obligations and that we no longer have grounds to take actions against the buyer after payment of the purchase price. You told the Commission that Mr. Obradovich took that position in 2012, correct?
That's correct.
Okay. If we could go to page 4, please. I'm going to start with the paragraph that says, in the middle of the paragraph, where it says, if this disposal of shares is permitted and the buyer is, I repeat, entitled to this in accordance with the agreement.
The interpreters apologize. Could you please help us locate the paragraph? Thank you.
I think we'll have it on the screen in a moment.
Thank you.
You said, if this disposal of shares is permitted and the buyer is, I repeat, entitled to this in accordance with the agreement, generally the agency would no longer be in a contractual relation with someone, and you would no longer be able to take measures against the contracting party when the legal ground had generally ceased with it, and the buyer would be free to dispose of its shares. That's what you told the Commission on the 23rd of April, 2015, correct?
That is correct. That's what it says here.
And then you will go on to describe a change in the law on privatization, and I want to just address this with you. You say, also, the new law, let us remind, in Article 37, paragraphs 8 and 9, prescribe that on the day of the certification of the agreement on sale of capital, the agency acquires a statutory pledge right against the capital, which was the subject of the sale, and it is obliged within 15 days after fulfillment of the last contractual obligation of the buyer to notify the competent registry for the purposes of deletion of the statutory pledge against capital. This provision of the law was, in fact, an attempt to, so to say, prevent and avoid that we had as a clear omission in our agreements, where we allowed disposal of capital during the validity of the agreement we generally allowed shares to be alienated, and we were still monitoring the agreement, which was a substantial problem. You see that?
Yes, I can see that.
So you were advising the commission that under the old law, the agency allowed shares to be alienated while you were still monitoring the agreement, and that it was a substantial problem, correct?
No, that is not correct. So this paragraph is about the fact that it is my duty to draw the attention of the Commission to the contractual and legal provision. The contractual provision was saying that the certificate on the pledge of the shares was to be kept by the agency until the purchase price has been paid. The 2014 law envisaged that when the agreement was established, the pledge was established, and that the pledge was to be deleted within 15 days following the fulfillment of the last contractual obligation. And we were supposed to implement this in this case too. In other words, at the moment when the request by the buyer for the deletion of the buyer, the fact is that the purchase price was paid at the time, because this happened, if I remember well, in early 2012. However, at this moment in time, as the buyer had not fulfilled his obligation, the agency obviously did not perform its own obligation to delete or lift the pledge from the shares. We thought this was justified, given that if we had done so, the buyer would have been able to dispose of the shares, and in this way, the role of this privatization agreement and the privatization process would have been pointless. And in addition to that, this would have created a practice for the buyer not to have any duty to perform on his contractual obligations the moment he pays the purchase price. And he could have done this much before. He could have paid the purchase price without fulfilling any of the contractual obligations because he had paid the purchase price. So this was what the agency was guided by when taking a decision on this. And this was the position that the agency had all the way till the end. What's more, I must add that the privatization agency on the issue of the deletion of the pledge did not have any problem whatsoever.
So it removed the pledge after the contractual obligations had been met.
I don't think that answered my question, but let me ask some follow-up questions then. You say here the change in the law we're talking about in 2014 was an attempt to prevent and avoid that we had as a clear omission in our agreements. What was the clear omission in your agreements?
The agreement said that the pledge would be removed after the purchase price has been paid. In cases of mala fide buyers, this was not the last contractual obligation. The point of having an agreement is for a bona fide buyer in performing the obligations, and the obligation that lasts the longest is paying the purchase price in installment. So the assumption is that by the payment of the last installment, the buyer would have fulfilled the other obligations. Before the payment of the purchase price, in this case, we had a breach of a contractual obligation, which would have meant that by removing the pledge, we would have opened the possibility for the buyer to dispose of the shares. We practically would not have had a contractual party from which we could require to meet the contractual obligations. This would have created a very bad practice for all the others, because no one would meet any obligations if they could dispose of the shares. And it was certain that Mr. Obradovich would be able to dispose of the shares very quickly. And this resulted from his letters and requests. Here, I also need to stress that in his request for removing the pledge, Mr. Obradovich was rather inert. If he was completely convinced that this was right, and he knew that the agency would not release the pledge until he had met all the obligations, he could have approached the court. He could have asked for damages. He had a lot of possibilities of action, but as far as I know, he didn't do it.
The transcript says, you said, we had as a clear omission in our agreements where we allowed disposal of capital during the validity of the agreements. We generally allowed shares to be alienated, and we were still monitoring the agreement, which was a substantial problem. That's what you told the commission, correct?
Yes, that's correct. It had to do exactly with this. You allow alienation of the shares by removing the pledge, and you allow the buyer to dispose of the shares while the agreement is in force and it's not been honored. So you have no further influence when it comes to the privatization agreement. You don't have a contractual party and no one to ask to meet the obligations. And the fact was that the contractual obligations had not been met. And this breach, I repeat here, was established before the purchase price was paid. The additional deadlines for rectification 534 started in 2009. In this period, the buyer was acting under these contractual obligations until 2015, when he had not repaid the 221 million loan.
This one more time. You say that the law was amended not because of a potential problem, but because, and you use the past tense here, we generally allowed shares to be alienated and we were still monitoring the agreement, which was a substantial problem. Correct?
No,
I don't use the past tense. I said if we had allowed this, this would have happened. And this is what's written here. If we had allowed for the capital to be disposed of during the duration of agreement, because you wouldn't have had the other contractual party in a situation where contractual obligations had not been met. That's very, very clear. Da pogledamo paragraf 28. vaše izjave svjedoka.
You say in this paragraph, it was concluded in the meetings of the agency that the only right thing was to keep the pledge on shares until Mr. Obradovich finally fulfills his contractual obligations. The stance of the Commission.
Izvinjavam se, paragraf 28.
I apologize. Paragraph 28 or 27 of the statement.
Note that there was a numbering error in your witness statement in the Serbian version versus the English version. So in your version, there are two paragraphs in paragraph 26, and then there's a 27. So the English version is paragraph 28.
Dobro, u
in the Serbian
originalu
version-
dokumenta obraćamo pažnju na koji paragraf, molim vas.
So could you please tell me in the original which paragraph it is?
Original Serbian version should be numbered paragraph 27.
Tako je.
Correct.
Of the English version?
That's correct.
Thanks.
Yep. So the last sentence of paragraph 27 in the Serbian version. You say, having this in mind, it was concluded in the meetings of the agency that the only right thing was to keep the pledge on shares until Mr. Obradovich finally fulfills his contractual obligations. The stance of the commission who decided upon this issue was that such decision was the only possible. Now, when you say the only right thing to do, you were aware that the contract required the agency to lift the pledge when the final payment had been made, correct?
To sam rekla već.
Yes, I have already said that.
Testimony that the only right thing for the agency to do was to breach the pledge agreement?
Znači, ugovor
The agreement established a certain obligation that you've mentioned or quoted here. In 2012, the Commission had already taken a decision that the conditions had been met to terminate the agreement. In August 2013, the buyer submitted a request for assignment of the agreement and concluded an assignment agreement with Koropi. All these facts led to the conclusion that the shares or capital would be disposed of. All this pointed to the fact that the agreement would not be honored through such actions. The aim of the agreement was to keep it in force, provided that all the contractual obligations are met. I will remind you of Article 41 of the law that says that in case of termination of an agreement, the capital will be transferred to the shares fund. If you terminate an agreement and the buyer disposes of the shares, you have nothing to transfer.
Long answer to a relatively short question. The question was, you say here in paragraph 28 of the English version of your witness statement that the only right thing was to keep the pledge on shares. And
Tako je,
the
to je bio-
question was
Sorry.
whether you were thereby saying that the only right thing was to breach the pledge agreement. You can say yes or no. If you have then to explain, you can, but I think it's important here that we try to focus on the questions.
Izvinjavam.
I apologize for trying to give a broad explanation, but these facts are important in order to understand this decision of the agency. A brief answer would be yes. The position of the agency was that this was the only possibility, given that the buyer had not met his contractual obligations, and so the agency for privatization did not meet its contractual obligation either.
This is always are eager to explain, and that's perfectly legitimate.
Thank you, Madam President. Thank you, Mrs. Vučković. If we could go back to the transcript, CE 768 at page 11, please. So, beginning with where you speak at the top of the page. So the agreement prescribes that the pledge is deleted once it pays the purchase price and not when it fulfills its obligation. And then you continue. And then you continue on, that is right, it violated one of the provisions of the agreement, and the release of the pledge is not tied to the fulfillment of contractual obligations. Rather, it is tied only to the payment of the purchase price, which was clearly done carelessly in the agreement. Now, the new law rectifies this somewhat, and it prescribes that the certain certificate on deletion of the pledge and fulfillment of contractual obligations is issued once all obligations are fulfilled, and not only the payment of the price. And that is it, and we are now between a rock and a hard place, because on the one hand, we have an obligation in accordance with the agreement, and the other hand, the consequences of this is clear to you. This discussion is what Madam President just asked you about. You were discussing the fact that you had to decide whether to breach the agreement or to go ahead and lift the pledge and then deal with the consequences, correct?
Precisely, this means that we discussed this issue in detail. And I have to admit, a broad discussion regarding this, deeply aware of what the agreement said, deeply aware of the consequences of the performance of the privatization agreements and creation of a bad practice for all future buyers who could behave in this way.
Okay, and if you scroll down a little bit further, another voice there says, if we consciously give it to him now, not even God could cleanse us. Do you see that?
Yes, I do.
What did that mean to you? Not even God could cleanse us.
Believe me, I cannot really comment on this.
Now, sorry, hold on, let me skip that. Mrs. Vučković, what kind of, well, let me ask it a different way. And let me preface it by saying, and I'm sure you're aware that these questions are going to be asked, but I will preface it again by saying our position is that you were once wrongfully suspected of a crime, and I want to emphasize wrongfully suspected of a crime in your capacity as an employee of the privatization agency, and that resulted in your arrest, correct?
Yes, that's correct. I wasn't an employee of the agency. I was director of the Center for Control. It was in 2012.
And you were arrested on the basis of some unjustified suspicions, correct?
The suspicions proved to be unfounded.
How long did you spend in detention?
I was in detention for 30 days.
Aware that the agency issued a press release when you were released from detention?
Yes, I was aware. I think my colleagues told me about it.
If we look, have you seen the statement before?
Ne.
No, I haven't.
The suspicions, well, let me bring up Exhibit CE 95 just to ask one question about it. Sorry, CE 895. I apologize. CE 895. This is an article discussing that case. The fifth paragraph from the top says, at that time, the labor union of Azotara employees warned all public authorities, the police, the judiciary, the ministries, the privatization agency, that a state-owned company was being robbed and that part of the factory was being sold without a permit. No one reacted then, and the plant was exported. Now the workers call for accountability of not only the owners of Azotara at the time, but also of public structures that had to react much earlier and prevent malversations. Is that what happened in the case where you were in detention for 30 days, that the labor unions had raised suspicions about the work of the agency?
I don't know if that was during the period when I was in detention. I would say that this was before that, because the trade unions had written to us that assets were being alienated from Azotara, and I remember that within 4 days we reacted to that letter. We sent a request to the buyer and asked for explanation. Since when performing control, the agency cannot stop people taking away assets from the factory, we also informed the police. I think we did everything that was necessary, but as you know, it's not a good idea for me to talk about it. That was a time when there were many criminal complaints filed against the agency for privatization by buyers or trade unions, regardless of whether we had terminated an agreement or not. That was simply a practice at the time, and there were many cases, but fortunately no one was convicted in any of those cases as far as I know.
Any criminal cases were filed against privatization agency personnel, which resulted in
Ja
acquittals?
zaista to ne umem da kažem.
I really cannot say that. Neither do I know it, nor is it in my AOR to have that kind of information, but this is what I know from my colleagues.
Ali niko nije osuđivan ni procesuiran.
But no one was convicted or tried for that.
Okay. If we turn to paragraph 26 of your statement, and let me check to make sure it's the same one in the Serbian version. Yes, and it's paragraph 26 in the Serbian version as well. You say there, unions have, so to say, immediately after the conclusion of the privatization agreement, started sending letters to the agency in which they complained about the actions of the buyer and non-performance of contractual obligations. That started, when you say immediately, you mean immediately upon the signing of the privatization agreement?
Baš tako kao...
That's exactly what it says here in writing.
To paragraph 15 of your statement, You say, in 2013, the Ministry of Economy initiated the supervision proceedings concerning the work of the agency in relation to the privatization of BD Agro, after a letter was sent by representatives of representative unions, as well as the strike board of BD Agro's employees, which were dissatisfied with the management of the company and hence requested termination of the agreement, reconsideration of business operations, as well as payment of salaries and contributions, which were due since 2009. So, if I understand correctly, your evidence is that it was as a result of the letter of the representative of the unions and the strike board that the ministry initiated the supervision proceedings over the agency's work in relation to BD Agro?
Izvinjavam se,
I'm sorry. I'm not sure if I understood you correctly. You said first that I said that immediately after the conclusion of the privatization agreement, the trade unions started showering the agency with letters complaining about non-performance of contractual obligations, which is entirely clear. Then it says, however, no decisions have been taken by the agency on account of the complaints by the trade unions. Had these complaints be able to impact the decision of the agency whether to terminate the agreement would have been terminated much sooner, because the trade unions, the shareholders associations were insisting that we needed to terminate the agreement many years before. So I do not see how these two paragraphs are related. The one that speaks about the oversight of the agency. The oversight of the agency did not start because we asked it to be started. It was started because the trade unions and strike board of employees asked for it to be started. Maybe I missed the context, the background of your question. I don't see the link there between the two.
Okay, you've answered the question as I posed it, which is, yes, the oversight of the agency did not start because we asked it to be started. It started because the trade unions and strike board of employees asked for it to be started. And I'd like to go back to the...
dobro, to su, izvinjavam se,
I'm sorry, these are facts that have been established also in the decision taken by the line ministry. We were just informed about the oversight procedure because we had to submit all the available documents related to cases within that oversight procedure.
If we go back to the transcript, CE 768, page 11.
kako? To je,
The voice there said, if we consciously give it to him now, not even God could cleanse us. Then it says, all right, then we can decide to not give it.
izvinjavam se.
Sorry. The female voice says, if we consciously give it to him now, not even God could cleanse us. And then Sasha Novakovic says, all right, then we can decide to not give it to the buyer, and then we are forcing him into suing us. This is, may the court rule. So it's fair to say that the commission preferred to breach the pledge agreement and be sued rather than comply with the pledge agreement, correct?
Agencija.
The agency decided to terminate the agreement because of violations of contractual agreements under 534. The agency decided that it would remove that is lift the pledge once all contractual obligations have been fulfilled, which is a fact Mr. Obradovich was fully familiar with, and maybe that's why he acted in such an inert way. He did not ask for compensation or damages. He did not sue us or anything of the sort. I'm sorry if I expounded on this too long, but I just felt the need to explain this.
I guess my question was hopeful. I was trying to be straightforward. Was it the Commission's preference to be sued by Mr. Obradovich for breach of the pledge agreement rather than to comply with the terms of the pledge agreement?
Mislim da je moj odgovor
I also believe I provided a clear answer. The privatization agency decided to terminate the agreement on account of violation of Article 534. Had the buyer, within the additional deadline, performed the obligations, that is, repaid the loans of Crveni Signal and Nova Varoš, Mr. Obradovich's pledge on shares would have been lifted immediately, and he was fully aware of those facts.
Let me turn to a different section of the transcript. Ms. Vučković, let's look at page 5 of the transcript. And this is now 6 lines from the bottom in the English version, and Ms. Penjar will help you find it in the Serbian version. We have an order from the ministry to provide an additionally granted term. You see that?
Gdje imamo nalog? Našla sam.
Thank you.
Izvinjam se.
No problem.
I found it.
And then if we go to page 7 in the English, the last paragraph on page 7, in the middle of the paragraph, 5th line from the bottom. So I think that the order of the ministry should be implemented as given. I am afraid that we do not have any maneuvering room.
Ovo.
Tako da mislim da treba sprovesti na ovo ministarstvo.
You see that?
Jesam.
Yes.
You told the commission, or you categorized the April 7 letter from the ministry as an order from the ministry when you were addressing the commission, correct?
Well, if the transcript says that this is what I said, then it must be true. My understanding of all the decisions issued by the line ministry were that they are, generally speaking, binding on the privatization agency, and this is how we acted in all privatization proceedings where oversight was conducted over the agency, and there were quite a few before this case and after this case as well. The opinion of the line ministry matched the fact that the line ministry was of the same opinion as the agency, and that is that contractual obligation under 534 had been violated and that the buyer should be given one more chance on top of all of the previous chances given to them to amend the situation, because we believe that this could be finalized successfully. And had it happened, the privatization agency, believe me, would have been very happy that it is so.
Is it the case that the agency decided to delay lifting the pledge on shares until after the 90 days given to Mr. Obradovich to comply with the agency's request?
I would phrase it differently. The buyer was given a 90 days time limit, but the buyer could have during the, I'm sorry, I have to rephrase. During the additional time limit, the buyer could, for example, repay the loan on day 2 or day 3, let's say. And after a few days, we would have lifted the pledge on the shares. So it depended on the buyer. What would happen? The time limit, the maximum time limit was 90 days. Had he done what he was supposed to do, had he repaid the loan under this on day 1, we would have confirmed that he had fulfilled the contractual obligations and the pledge would be lifted practically immediately. There's no dilemma about that. These are facts. In this case, facts which are valid in this case and in other cases.
Madam President, may we have one moment just to consult?
Sure.
Thank you. Madam President, we have one document left that we'd like to show the witness, but it's not in the bundle, so we'll have to show it on the screen if that's okay with you.
Sure.
This is Exhibit CE 47. It is a, I don't think there's a copy in the bundle there, so it is a letter from the agency addressed to Mr. Markicevic and to Mr. Obradovich. Do you need to see a copy of this in the Serbian, or can you follow in the English?
It may be fair to...
Svakako.
Okay, let's
I do need a copy in Serbian, please.
Are you familiar with this document?
Verovatno da je, mislim,
Most probably, I have seen this, but I would have to go through it to be sure about it. Take a look, read it.
Okay, let's scroll through it. This is the notice that was sent in July of 2015 concerning compliance with the agreement. You see that?
vidim.
Yes, I do.
In the Serbian, There is...
Jel možete samo malo sporije?
Slow it down.
We were not sure whether something had not been translated, but
No, everything was translated. It's all covered. Yeah.
Nema prevoda.
Just if you would just let us know when you would like us to turn the page, we'll turn the page so you see the whole document.
Molim vas, sljedeća strana.
Okay, the next page, please.
Da, sećam se ovoga dokumentu. Možemo ići dalje.
Okay, then we'll continue. So this is...
Sećam se.
So I do remember this document. We can move on.
I just want to go through the bolded points of what you were asking Mr. Obradovich and Mr. Markicevic to do to be in compliance. The first was to provide an unequivocal statement on the performance of the obligations of the buyer referred to in Article 533 of the agreement concluding with April 8, 2011. Correct?
Tako je.
That's what it says, yes. But I believe I said that during my responses to your questions.
The next point was to provide a statement on performance of obligations of the buyer referred to in Article 534 of the agreement, concluding with April 8, 2011, and confirm that all encumbrances have been deleted and all other security instruments for the obligations of third parties have been returned, and all encumbrances which have been registered on no grounds were deleted, as well as that all loans given to parties by the subject of privatization from loan amounts secured by encumbrances on the property of the subject have been returned. Correct?
Correct.
Confirm that all fixed assets sold until April 8, 2011 were paid and used for the needs of the subject.
Da,
Yes, that's what it says.
If I can just stop there, what that meant was from the moment that the privatization agreement took effect until April 8, 2011, the buyer was supposed to provide proof that any assets sold in that 6-year period were used, the proceeds were used for the benefit of the company, correct?
da.
Correct.
The next bullet point is confirm that the buyer made the investment without encumbrances and capital increase in line with Article 521 of the agreement in the value of sold fixed assets which are the subject of performance of the investment obligation of the buyer, 202,245 euros, correct?
Tačno.
Correct.
Performance of the total investment obligation is not the subject of a pledge mortgage, correct?
Nije da...
Okay. If you could just confirm that you were asking Mr. Obradovich and Mr. Markicevic to confirm that the subject of performance of the total investment obligation is not the subject of a pledge mortgage, correct?
Yes, correct. That's what we asked the buyer to confirm.
And the buyer had to complete all of these conditions by the end of September, or else the agreement would be terminated. That's what happened, correct?
we asked the buyer to submit certain evidence, given that, as you know, the last subsequent deadline for the performance of obligations was given in 2012, and that the buyer's conduct was not considered. This was the first occasion when we discussed and analyzed all the obligations that he was given back in 2012. This was November 2012. The audit report was given in December 2012, and then there was this time in 2015.
Tako da Agencija za privatizaciju.
So the privatization agency never stated its opinion on this, and it was logical for the agency to repeat all this when it made its final decision, namely to say that the buyer has or has not performed on the obligations from the agreement.
Yes, but if you look, let's look at the last sentence of this document. First, let me ask this. The buyer you were telling the buyer that they had to complete all of those conditions, correct, that I just read out?
Mi smo tražili
We asked the buyer to submit evidence on all the parameters that you've just read.
Dated July 22nd. The letter is dated July 22nd. And if you look at the last paragraph, you give him an additional term to July 27th. So you gave him 5 days to fulfill all of these conditions, correct?
Yes. I'd formulate it more precisely. The buyer was given this additional deadline in April. The extension was 90 days then, following the audit's report and the not audits, but Ministry of Economy's report. The buyer was given 90 days, starting from April until the 27th of July, within which he was supposed to submit evidence showing that he had acted upon this and complied with all the obligations. After this deadline, he submitted part of the evidence, part of the documentation. And we said, we accept that we gave a concrete list of the obligations that had been fulfilled. And then we say, because you have submitted certain evidence during the term of this additional deadline, please submit other evidence before the expiry of this additional deadline. We did not give him 5 days. The term lasted for 90 days. The buyer submitted part of the evidence for the duration of the agreement, and then we said, please do some other corrective action before the expiry of the additional deadline. Whether this was 5, 7, or 8 days, I don't know. But the agency did not say to the buyer, you have 5 more days. The buyer could act at any moment during this term, and he also could have submitted his evidence on the 27th of July 2015. So I think that acting in this way, we actually did accommodate the buyer. And let me repeat, and I apologize for repeating, the aim of this was to see that the buyer fulfills his obligation, because we believed he would do this after this much time. We truly believed he would comply.
Thank you, Mrs. Vucic. Thank you, Madam President. That concludes our cross-examination.
Thank you. Any questions in redirect?
Can we have 2 minutes, please,
Sure.
to consult? Thank you. Thank you
Ms.
for
Waive.
waiting us. We have no questions. Thank you.
Sometimes it's worth waiting. Do my colleagues have questions? Yes? Can you please go ahead?
Good afternoon.
Good afternoon.
A distinction is being drawn between economic justification for termination and legal justification for termination. I understand very well legal termination. Can you help me understand a little bit better what would be an economic justification for termination?
With all due respect to your question, I cannot explain this, given that the privatization agreement has a very clear provisions. Our role was to control the performance of the contractual obligations, and in case these obligations were not fulfilled, we were to grant the buyer an extended deadline by which to rectify the situation. If this was not done, we were there to terminate the agreement. That was our mission, so to say. We could not look into the economic aspect only, given that the contractual obligation was not performed. I'm actually referring to any obligation, not a specific obligation.
Yes, but when you looked at the ministry's opinion, and that was an economic, they said there's no economic justification for termination, what did you understand by economic justification for termination?
Our interpretation was that this was not the opinion that fully described how one should behave in the privatization entity. We had never received such an opinion. I must add something. Had we looked at the economic aspect only, BD Agro Dobanovac, which it was obvious from one year to another was going down in terms of its economic performance in 2012 only, based on the audit reports and the financial reports, it was obvious that the active interest rates for the loans made almost 100% of the revenue of the company. But the buyer did ensure continuity, and with ensuring this continuity, the buyer performed on this obligation. We had no reason to look into this issue any further.
As a matter of law or even practice, can the privatization agency waive a breach by a buyer?
No. Not that I know of. Contractual obligations must be performed, and this must be followed by a certificate, and to make sure that the agreement was performed. We can't partly accept it. If I understood your question correctly, we can't say one of the obligations was not performed, but that's okay. We can't act in this way. This is not in line with the concept of the privatization procedure or the contractual law when it comes to the application of the privatization law. We simply did not have legitimacy to do this or to act in this way.
But what if the breach was obviously de minimis? So let me give you an example. In an ordinary commercial relationship, let's say I'm buying oranges from you, and you've given me 49 instead of 50. Instead of saying you haven't performed, maybe I say it's okay, you're one short, and let's move on because we have other things to do. Can you not do that?
Ne smemo.
We can't do that. Definitely no dilemma on that. Contractual obligations must be fully performed, every one of them, for the privatization agreement to be considered fulfilled, and for the buyer to be able to dispose of the capital and to organize and manage his operations in the way which is in line with the applicable legislation of the Republic of Serbia and the market conditions. And the loan, the disputed loan, which was the reason for termination here, in some contexts, such as the sale of the oranges you mentioned, it is an obligation. If I give you a loan and you have the obligation to repay the loan, that's as simple as that. It's a matter of the two parties entering into a contractual relation.
My final question, if you could be shown CE 17, please, clause 9, which is the dispute resolution provision.
Napred.
Now, reading this, it's apparent that either party can be the plaintiff in bringing a dispute under this provision. Am I reading it correctly that the privatization agency could also be a plaintiff and not just a defendant in a dispute under that clause?
That is correct.
Okay, and can you give me some sort of example of the types of disputes that the privatization agency would be a plaintiff in under this type of clause?
I apologize. I want to respond, but the role of the Center for Control and the Commission for the Control of Contractual Obligations was exhausted with the fulfillment of the agreement or with the termination of the agreement. So I'd rather not respond and maybe give a wrong answer that I would not be fully sure about. So we've had situations where the privatization agency was the plaintiff.
Thank you.
Dobar dan, Madam Vuskovic. With your permission, I will continue in English. I have a couple of questions. You mentioned in your statement that according to Mr. Obradovich, the breach of 534 of the privatization agreement, if existed, would be insignificant. Could you compare this alleged breach with other cases of termination of privatization agreements you may have in mind?
Are you asking about the breach of 534 specifically, or any breach of any agreement in general?
Mislite li samo na povredu?
So are you asking about the breach of 534, or are you asking about breaches in general? I can cover both. Okay. So we've had some loans that again involved placing a pledge on the assets of the privatization entity, and the sum of these sums were smaller than the sums relating to Crveni Signal and Nova Varoš. We've also had terminations relating to the investment obligation, when the investment that was paid into the privatization entity within the terms that were set by the agreement, but was not functional or was removed from the entity on various grounds. And for that reason, we had some cases where we terminated those agreements. And this is a reply to your question. The obligations that were smaller than the one that Mr. Obradovich called an insignificant breach. So in these other cases, agreements were terminated because the obligations were not fulfilled. So agreements are terminated if obligations are not performed, and the obligations were not that stringent. And the privatization agency granted numerous times extended deadlines and tried to act in a preventive manner to point to various options in which the buyer could fulfill these obligations. We made every effort to keep the agreement going. That was our main idea of any privatization process, to keep the agreements going.
Thank you. So my next question is the following. Do you consider that not having respected the contract stipulation according to which the pledge would be released after the full payment of the price, in this case, would the agency breach the law?
Yes,
I apologize. I'm not sure absolutely I understood your question fully. Would you be so kind as to repeat your question? I apologize.
Yes, of course. So there is a contract stipulation according to which the pledge should be released after the full payment of the price. Is that correct? Huh?
to nije slučaj.
No, that is not the case. I can't see any connection between the two. The obligation from Article 534, which is relating to the prohibition to place a mortgage on assets without the approval of the agency, in some cases lasts for as long as the agreement has validity, and the obligation from 533, which refers to the disposal of the assets, the sale and disposal, lasts until the payment of the purchase price.
My question is the following. There is a stipulation in the contract according to which the pledge must be released if the full payment is perfected, accomplished. This is something you have been discussed with Mr. Misetic.
Yes.
My question is the following. If the privatization agency would not respect this contract provision, would the privatization agency breach the law? Do you understand my question?
Razumem.
Yes, I do. Thank you. If the agency hadn't observed this contractual provision, if it had not returned the pledge as such, at the time when the buyer paid the purchase price, was not defined by the law. It was defined by the agreement. In 2014, the law introduced a provision which set forth that the lien was established at the moment the agreement was concluded, and it was to be deleted or lifted after all the contractual obligations had been fulfilled. Essentially, Article 41A, if it was valid at the time the buyer paid out the purchase price, said the following: in the event of a termination of the agreement, if the buyer fails to perform on his obligations, the capital concerned is to be transferred onto the shares fund. And in a way, it would have been in contravention of the law had we lifted the pledge from the shares.
Have any further question, Madam President?
Thank you. Mrs. Vukovic, when you were discussing with counsel the fact that for you, Mr. Obradovich was the owner of BD Agro, and you went through the different documents where you had other people attending the meetings, you said that whatever financial arrangements or relationships existed between Mr. Obradovich and Mr. Rand, this was completely irrelevant to you because what counted for you was who signed the privatization agreement. Did I understand this correctly?
Yes,
Yes, you have fully.
Thank you. And then on several occasions, you insisted that you had never had any communication, neither oral nor written, with Mr. Rand. And I was asking myself why you were saying this, because if what matters to you is who signed the privatization agreement, then why would you tell us that you didn't speak to Mr. Rand? Why is that something you want to tell us?
I wanted to mention this for a simple reason, that at these meetings it was mentioned that Mr. Rand and Mr. Juro Obradovich were in some kind of a financial relationship. And at one of the meetings, I'm sorry, I do not remember the name. I apologize. I can't see the name. Mr. Mišetić. I'm sorry, I apologize. Yes, Mr. Luka Mišetić said that at those meetings it was mentioned that he was in a financial relationship with him and that he was not happy with the work of Mr. Obradovich.
And I don't think you need to repeat. We have
to je
understood
bila moja
this well.
potreba da to
I simply felt the need to explain this, given that at these meetings we were given this information. And I simply want to say that we had this information, but this was not sufficient for us to view any other statements. We simply focused on the fact that we have in front of us the buyer of the capital, Mr. Juro Obradovich, who behaved in every respect as the buyer of the capital, as someone who controlled the shares in the privatization entity, that is the company.
Ask my question differently. If Mr. Rand had come to Belgrade and he had come to visit you, would that have made a difference to you?
I haven't met. When I took office as director, we had around 2,000 privatization entities, and I claim with full responsibility that in none of these other 4,000 agreements we had a similar situation. Had we had any evidence that Mr. Rand was potentially the owner of the capital, we probably would have informed the competent authorities of this and tried to establish the facts. But for the duration of this procedure, at no moment in time, I apologize, I need to give a personal comment, but had I been an owner, I would have been interested very much in what was going on in this company. I would have been interested in what was happening with the extended deadlines, what constituted the violations. I would have asked for a meeting, but this has never happened. So that's why I had this need to explain this. We, as the Center for Control, did not at any moment have any knowledge of a third party being the owner. Mr. Obradovich never mentioned this himself. And as I mentioned earlier, we had numerous meetings and he had never brought this up.
Yeah. You have on various occasions during your testimony referred to bona fide buyers, and you have also sometimes referred to a mala fide buyer. Do you mean by that someone who is not performing? If I'm mala fide, does it mean that I'm not performing my contractual obligations, or does it mean something else, that I am in bad faith? There are many reasons why you don't perform an obligation, it doesn't mean that you're in bad faith. So I'm just trying to understand what you mean when you speak of bona fide and mala fide purchasers.
In the context in which I mentioned mala fide buyers, I was referring to buyers who were not performing their obligations. That was the only interpretation or the meaning in which I used the term.
When we discussed the meeting of the 23rd of April 2015 and the transcript, you emphasized that in the meeting that the new law would rectify the omission in the prior law that conditioned the release of the pledge exclusively on the price on the payment of the price and not on the fulfillment of all of the obligations. I think we can go there. It's on page 4 of C768, but I think you have repeated this orally as well, but you can look at it, of course.
Samo malo. Tačno, koji deo? Ako se dosledno...
There's a sentence that says, now that you say, now the new law rectifies this somewhat and then prescribes that the certificate on deletion of the pledge and fulfillment of contractual obligations is issued once all obligations are fulfilled and not only payment of the price. Do you see this?
Ne vidim, mislim da nije.
I can't see it. I don't think the translation followed the text. The interpreter apologized. I couldn't find that part in Serbian either.
You have the right,
Yes.
maybe my quote is incorrect.
The quote is on page 11, and we're
Oh,
highlighting
thank
it on
you.
the screen.
Thank you, yes.
Da, to sam već komentar.
Yes, I have already commented on this.
Seen it again. And then you have explained to us what in your witness statement you called the biggest dilemma, and what in the meeting you mentioned being between a rock and a hard place, which was to decide what to do with the shares, because the price had been paid, but in your view, some other contractual obligations had not been performed yet. And when you explained that you decided to not release the shares, one of the explanations you gave is that this would create a bad precedent, because then a purchaser could pay the price immediately and never fulfill the obligations. Now, I'm not certain that I understand this reason, because there was this other law that did change this situation, was it not? Did it not?
Yes, the law did change the situation in 2014. I was talking about the possibilities that existed before that, because natural persons who were buyers bought capital and had the possibility to buy through installments. The provision in the agreement was that they would pay the price in 6 installments. The buyer had the right to pay this earlier. If paid earlier, then the ban on disposal can last only up to a year, which means that at the moment when they paid the price, we should have removed the pledge after 1 year, whereby you have the obligation to invest over a period of 2 years. You have the obligation to pay the wages. You have the obligations from the annexes to the agreement regarding the social program, and that's payment of severance packages, of dividends, continuity of operation. If you were to remove the pledge after 1 year, whom would you ask that from to fulfill all those contractual obligations?
And about not releasing the pledge in 2015 when the new law was already in existence, or do I miss the chronology?
Yes,
So
the-
the
yes.
explanation with respect to earlier situations is not really pertinent.
Pa relevant.
It is pertinent, and you know why? Because the buyer's request to have the pledge removed came in January 2012, when this law hadn't entered into force yet. And he repeated this request from time to time. In 2014, when this law came into force, this contractual obligation was corrected in a way, and it would have been then contrary to the law. So I believe generally that we did not make a breach here when it comes to the application of legal provisions.
I have no further questions. Any follow-up from council?
Nothing from our
No.
side.
From
Thank
the
you, Madam.
respondent, is that
Thank you,
it?
Madam President. We have no further questions.
Good. Fine. So, Mrs. Vukovic, thank you very much for all your answers and this and
Hvala vam.
your examination.
Thank you too.
And this is time for the lunch break. Should we take? I have. Yeah. Until 1:30. Is that fine?
Yes, that's fine with us.
It's fine with you? Fine. Excellent. Good. Have a good lunch. We ready to resume? Yes?
Yes, Madam President.
Good. Mr. Svetkovic, good afternoon. Do you hear the, oh, are you going to use the interpretation?
I'm going to speak in Serbian, if that's okay.
Yes, then you will need the headphones.
All right.
Fine.
Thank you, Mr. President.
Do you hear the interpretation now when I speak?
Yes, I do. Yeah.
Good, fine. So, can you please confirm your identity of Vladislav Svetkovic?
Da, ja sam Vladislav Cvetković.
Yes, my name is Vladislav Cvetković.
You're was Pricewaterhouse Serbia since 2013.
Tako je, gospođo.
Yes, that's correct, Madam President. I have worked in Pricewaterhouse Serbia since late 2013 or early 2014 after I had stopped working at the agency.
The Privatization Agency as director, and before that as deputy director from 2007 to 2013. Is that correct?
To je tačno.
Yes, that's correct. 2007 to 2009, I was deputy director. From 2009 to September 2013, I was director.
You have filed one written witness statement that is dated the 4th of April 2019.
Tako je.
Yes, and
That's correct.
there I assume, yes, fine. You're heard as a witness. And as a witness, you're under duty to tell us the truth. Can you please see if you find the witness declaration that is on the table? Can you please read it aloud into the record?
Svečan.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
So I'll first give the floor to Respondents' Counsel,
Thank you very much,
please.
Madam President. Good afternoon, Mr. Cvetković. My name is Vladimir Đerić, and I'm counsel for Respondent. Let me start by asking you, have you had a chance to review your witness statement recently?
Da, imam.
Yes, I have had an opportunity to review it.
You would like to amend or clarify in your witness statement?
I would like to give some clarification in connection with item 5 of my statement that speaks of the relationship between the Ministry of Economy and the Privatization Agency. Perhaps the formulation is not quite precise in the last few lines. I will just explain here briefly what it has to do with. The Privatization Agency performed administrative supervision that had to do with, that is, the ministry checked the legality of the work of the agency. This is all said in one sentence here, so this clarification is perhaps needed because those are two different things. One thing is administrative supervision over the work of the agency in terms of its legality. And the second form was that of the ministry being the second instance authority in case of complaints against the work of the agency, for instance, concerning an auction process or some other process conducted by the agency, and a party could appeal with the ministry as a second instance authority.
About the position generally between the privatization agency vis-à-vis the Serbian government and the Ministry of Economy.
As for the privatization agency, it had a clearly defined mandate and clearly defined responsibilities that were entrusted to it through the law on the agency and, of course, the privatization law. When it comes to its work, the agency conducted all the activities independently, and its mandate was clear in terms of its manner of operation and its model of responsibility. Both things were clearly defined in the law. The agency was completely independent as a professional body in its work that had an area of responsibility that included the privatization process in Serbia. So just briefly, the agency was independent and professional in its work.
It's about how the agency was being managed at your time. Within the agency.
Da.
The agency had a director in this period. This is the period when I headed the agency. The director was independent and in charge of performing duties in the agency, just like a director in any other entity. When it comes to the organizational work, since the agency had a very important mandate and a lot of responsibility, it organized its work through its units and departments. And each of those had their clearly defined responsibilities. So in operational terms, these were the things that were important for the function of the agency. Of course, the agency also had a managing board that adopted financial reports and the agency plan, and that was kind of a supervisory body in this system of direct responsibility for work. So this would be the most important elements of the structure of the agency.
Could you now tell us specifically about the workings of the Commission supervising the compliance with privatization agreements and its decision-making process?
The Commission was a body that, at the proposal of the Control Department, and this is now linked to your previous question, so the Control Department prepared materials and everything that, in technical terms, was necessary for supervision over performance of contractual obligations. And the Commission itself was a body that looked at these materials and took final decisions as to whether additional deadlines will be granted to buyers, whether they have met all the provisions of privatization agreements. The department prepared materials, the Commission discussed them, and gave a final opinion as to whether all the conditions have been met. Those were the two main bodies of the agency.
The way how the sessions were conducted, etc., you were sitting at these sessions in your capacity as the president, as the director, sorry.
Što se tiče sastanaka,
as for Commission meetings, They were convened once the control department had prepared materials and submitted them to the Commission for decision making. And the Commission met as necessary. In periods where we had more privatizations, we of course had more cases discussed by the Commission. The materials were prepared by the control department with proposals as to what should be adopted. The Commission had an odd number of members and could decide through votes. But after these discussions, the Commission, in most cases, took decisions unanimously. And once the Commission took a decision, the material was sent to the buyers as the decision of the agency in terms of further actions.
Of the agency and disbursement of the funds, and how it was, what was the decision-making process in that regard?
When it comes to the finances of the agency covered its expenses through the revenues that came from a certain percentage of the purchase prices paid in privatization transactions. The agency independently filled its budget from privatization proceeds, and based on these own revenues, it covered its operational expenses. Like any organization, paid the salaries of its employees and covered other operational expenses.
It's always the problem when you understand both languages. You tend to start your question before the end of the interpretation.
Yes. Yes. Thank you. We don't have any further questions. Thank you, Madam President.
Fine. Mr. Henry.
Good afternoon, Mr. Cvetkovic. It's a pleasure to meet you. My name is Stephen Anway. I am counsel to the claimants in this arbitration, and I'll be asking you a few questions about your witness statement today. We have quite a lot of material to get through, so I would ask that you please listen to my questions carefully and try to answer them succinctly, preferably with yes or no answers. If my questions are unclear, please let me know and I'll rephrase them. Because we have a translator, it's especially important that you let me finish my question before you begin your answer so we don't speak over each other. You understand? Mr. Cvetkovic, I think in response to Madam President's questions, you stated that you were at the Serbian Privatization Agency from 2007 to 2014, correct?
To je tačno.
Yes, that's correct. But for the sake of precision, I was at the agency until the end of 2013. I handed in my resignation in September, but it was adopted in November. So it wasn't 2014, but the end of 2013.
Question I was going to ask. The term for a director at the privatization agency statutorily is 5 years, or was 5 years. Is that right?
If I remember it correctly, the term of the director was 5 years at the time I was there.
Not finish out your 5-year term, correct?
If I started in 2009 and finished in September 2013, we can now do the math together.
Tell us a little bit about the circumstances behind your departure.
There were no special circumstances that I would comment on. At the time, I decided to devote myself to a different part of my professional career because I had already spent quite a lot of time at the agency, and this decision was a result of that.
2009 until September 2013, you were director, correct?
That's correct.
And the director was the highest individual position at the privatization agency, wasn't it?
Tako je.
Yes, he was.
You are not a lawyer?
Ne, ja sam
No, I am economist and accountant by training.
No formal legal training?
sem nekih kurseva
With the exception of some courses that I had during my studies that concerned legal matters, other than that, no.
Or positions to the tribunal, correct?
ja sam ovde kao
I'm here as a witness, and I don't think it's necessary for me to offer legal opinions outside of what I can comment on.
Let me just make sure I understand the structure of the privatization agency correctly, and I may leave out a few departments, but insofar as these different departments are relevant to this case. First, the privatization agency had a management board, is that right?
tako je.
Correct.
And that management board was comprised of 5 members, 1 president, and 4 other members, is that right?
Yes, I believe it was so.
The privatization agency also had a center for control, correct?
Correct.
And that was part of the control sector, which conducted the control of compliance with the privatization agreements. Yes?
To je tačno.
Correct.
And in the event that it was established that a provision of one of the privatization agreements was violated, the control center would notify the Commission for Control, correct?
Correct. Though I would also add that the control center would perform its part of the work and submit proposals to the Commission on what to do next.
But the Commission was the body that made the decisions itself, for example, on whether to terminate a privatization agreement, correct?
Konačno,
The final decision was taken by the Commission, but exclusively once they would receive a proposal from the Department of Control, which had to contain a statement of reasons, an explanation of why that needs to be done, in other words.
Yes. And if the Commission decided to terminate a privatization agreement, it would not give back the purchase price to the buyer, correct?
Well, seeing that all proposals coming from the control department were based exclusively on the proposal, on the provisions of the agreement, the Commission would receive a proposal to do that. It would take its decision based on the contractual obligations of the buyer. So I would say yes, in most cases that was the procedure. Those were the steps.
Testimony, sir, that in some cases the privatization agency could give back the purchase price to the buyer if they terminated the agreement?
mislim da
I believe that we haven't had any such cases, from what I remember now, of course.
Okay, why don't we turn to CE 220, which I'll represent to you is the law on privatization. I understand you're not a lawyer, sir, but I just want to ask for your understanding of this as the highest ranking individual at the agency. And if we could turn, please, to Article 41A, the very last paragraph. Right there. So I'm picking up
41, posljednji paragraf.
I'm picking up with the language in the case of termination. You can read with me. In the case of termination of the agreement on sale of the capital or property due to the failure of the buyer of the capital to fulfill the contractual obligations, the buyer of the capital as a dishonest party shall have no right to the refund of the amount paid as the purchase price in order to protect public interest. Do you see that?
Da, pročitao sam.
I've read the paragraph, yes.
Was it your understanding then, having now seen this provision, that in fact, if the commission terminated a privatization agreement, it would not give back the purchase price to the buyer? Correct?
Moje razumijevanje.
To my understanding of this article, the Commission isn't empowered to take a decision thereon if it's already governed by the law.
And it's true that this provision is specific to the privatization agreement. I'm sorry, to the privatization agency, correct? It doesn't refer to private citizens, for example.
Well, if I understood your question fully, does this relate entirely to the work of the privatization agency and not others? I'm not a lawyer, so as such, I can only tell you that as the privatization agency, we had to stick to the wording of the law exclusively.
And as a non-lawyer, you don't have an understanding about whether, if there's a share purchase agreement between two private parties, the seller would generally owe the money back to the buyer in the event of termination. You have no personal knowledge of that or understanding. Is that fair?
Ne mogu da kažem.
I cannot tell you this because I do not have this type of legal background, legal education. However, I have to repeat, the wording of the law, the text of the law was something that the agency was adhering to, and that is something that we were led by when we were carrying out certain actions in privatization proceedings.
Fair enough, and I think we'll leave that question to the Serbian law experts. Let's turn now to paragraph 4 of your witness statement, please. And you expounded upon this idea, I think, earlier in response to Serbia's counsel's questions. You state, quote, in accordance with the law, the privatization agency was making decisions independently without interference from the Ministry of Economy. Do you see that, sir? And my question's only whether you see it.
May I just correct that the
Yeah,
reference is to paragraph 5?
Oh, I'm sorry.
Upstairs.
I apologize.
Sorry.
Thank you.
Da, tu ispred mene vidim ga.
Yes, I can see that.
Okay, I'm going to ask you a series of questions now, and for each question I can take you to the relevant document if you want, but I think most of these questions are undisputed and may save time. In any event, if you want to see any of the documents behind the questions that I ask, please do ask. First, could you please tell us who appointed you to your position as director of the privatization agency?
Po mom,
According to the best of my recollection, there was a public competition, and formally speaking, well, I do not actually remember exactly, was it at the proposal of the steering board or not? But the final appointment, I believe, was done by the government of the Republic of Serbia, but that was after the public competition procedure was conducted.
Thank you. And in fact, all of the directors of the privatization agency were appointed by the government of Serbia, correct?
I believe it is correct. I believe there's a provision governing that. I believe most probably this is stipulated in one of the relevant laws.
And we established earlier that the privatization agency had a 5-member management board. Do you recall?
Yes, I do. U kom telu je... Sorry?
And which body was in charge of appointing each of the 5 members of the management board?
I do not recollect exactly. I would have to consult the text of the law. So if you have a relevant document to assist me in responding this, I really could not reply.
CE 238, and I'll direct you to Article 12. If you just take a moment to read it, that may refresh your memory.
Da, pročitao sam.
I have read it.
For the record, then, which body appoints each of the 5 members of the management board of the privatization agency, please?
Da.
It says here in Article 12 that they are appointed and dismissed by the government of the Republic of Serbia, out of which at least one is proposed by the body of territorial autonomy.
Earlier that the Commission for Control within the privatization agency ultimately makes the decision about whether or not to terminate a privatization contract. Do you remember that testimony?
I do.
And I think we agreed that the Commission has 5 members, 1 president, and 4 other members. Is that right?
Does your question relate to this managing board or the commission itself? The commission itself, by definition, did not have 5 members. I believe there were periods when it had more members, but it had an odd number of members. That is the commission that decides on the proposals of the control department.
Article 15B of the same document. And I'll refer you to the 3rd paragraph where it says, and I quote, "The commission shall have 5 members, out of which 1 shall be the president of the commission." Do you see that?
Da, mislim da...
Yes, I believe I'm trying to figure out what this is. I believe these are amendments to the law on privatization agency, which were introduced once I wasn't in that position, so I believe that these were the most recent amendments to the law, if I'm not mistaken.
Indeed, in fact, they were amended in 2014. But you can confirm from the first sentence of Article 15B that after these amendments were passed, the ministry in charge of economic affairs, which I understand to be the Ministry of Economy, shall establish the Commission for Control. Correct?
Ja mogu samo da...
I can only confirm that this is what Article 15B says, but it might be more relevant to say that when I was the director of the agency, that is not the way in which the Commission was established and in which it functioned.
Of the Commission while you were director of the Privatization Agency.
Članove...
The members of the Commission, formally speaking, were appointed by the director, and as a rule, these people were directors of departments within the agency, meaning colleagues from the agency managing various departments, people who are very familiar with the privatization process and the work in which the agency was operating. And that's how it was set up, it was established. Its members were the most prominent, most renowned professionals within the agency, most commonly directors, that is managers of various departments.
2014 in these amendments, the positions of the Commission were appointed by the director himself or herself. But as we see from the first sentence of Article 15B, after 2014, and therefore at the time when BD Agro's privatization agreement was terminated, the Ministry of Economy appointed the Commission members. Do I understand correctly?
I can only say that these amendments to the law happened after 2014, as you said yourself.
18, and I think this is along the lines of what you were describing earlier. You see that Article 18 says that the supervision of the work of the agency shall be done by the ministry in charge of economic affairs. Do you see that?
I do.
And it goes on to state that at least 2 times a year the agency needs to report to the Ministry of Economy. Do you see that in the next paragraph?
Da.
Yes.
Director, did you provide at least 2 reports to the Ministry of Economy each year?
To the best of my recollection, although I do not remember this precisely, the agency was delivering its reports to all those who were allowed by law to receive such reports. So that relates to the ministry, to the government, to the parliament. These were periodic reports, and it was governed in writing how to submit them and within which deadlines to submit them to those institutions.
I'd like to turn now to your witness statement and a paragraph that I think you sought to clarify in your opening remarks in response to questions from Serbia's counsel. I'm focused on paragraph 5 and the last sentence where you talked about the Ministry of Economy and its, quote, second instance authority in the privatization agency's decision-making procedure. Are you there? I'm wondering if you can help me understand a little bit more what you mean by second instance authority in the privatization agency's decision-making procedure, perhaps with an example. Could you give us an example of an instance where the Ministry of Economy exercised second instance authority over the agency's decision-making procedure?
This rule actually meant that if a participant of a privatization procedure had some issues or objections, complaints against the agency, if such a party felt that its rights were not observed in a way envisaged by the law, in those situations, the ministry could act as a second instance authority and review the complaints and see whether there are any grounds for the complaints or not. For example, if a participant in an auction felt that he was disqualified for no good reason, if he hadn't met conditions to participate in an auction, he was free to submit a complaint with the ministry.
E328. No, I take it back. Let's turn to CE206. I apologize. Mr. Cvetkovic, I will represent to you that this document.
Daćete mi samo sekund, pošto je tek sad.
Could I just have a moment? I've just received a document.
I recognize this may not be a document you've.
Ovo je dokument koji možda niste imali priliku ranije da vidite.
Upravo ste, nisam imao priliku.
You are right. I've never had a chance to see.
And all I'm trying to understand is whether this would be an instance where the ministry would be exercising its, to use your words, quote, second instance authority. It's a document dated December 23rd, 2013 in connection, from the Ministry of Economy in connection with the BD Agro privatization. And you'll see the decision there in the very first page is to initiate the procedure of supervision of the work of the privatization agency. Is this an example of what you describe in paragraph 5, or is this something different?
I haven't read the document in its entirety, but I will go back to my additional comments on paragraph 5. So this is not such an example. This is an example where a decision was issued by the ministry to initiate the procedure supervision. This is not an example where someone filed a complaint to complain against the work of the agency. This is an example of a different procedure, something that has to do with supervision of the legality of the privatization agency's work.
That's very helpful. So there, in fact, what you're referring to now, together with this letter, are two different types of involvement that the Ministry of Economy may have. One, as you describe it in paragraph 5 of your witness statement, is when it exercises, quote, second instance authority in the PA's decision-making procedure. And the other is when it may initiate the procedure, quote, of supervision of the work of privatization, which is on CE 206. And that is to review the legality of the privatization agency's actions. Do I understand correctly?
That is the only conclusion I can reach, given that I haven't had the time to read this carefully. I've only looked at it now, so I can assume that, yes, this is the case in this decision.
And we saw earlier in the first paragraph, in the first sentence of paragraph 5 of your witness statement, that you stated, and I quote, "The PA was making decisions independently without interference from the Ministry of Economy." But isn't it true, sir, that in fact the agency sought instructions from, and indeed received instructions from, the Ministry of Economy with regard to privatization projects?
I'd say that the agency could seek an opinion from different institutions, including the Ministry of Economy, which addressed the policy making of privatizations in general. But agency, on its own side, had a very clear mandate over the implementation of the law that regulates its work, and also relating to some other authorizations that they had based on that law. Opinions could be sought and they could be discussed, but the agency, in all these instances, has taken decisions in line with its statutorily defined authorizations.
You distinguish between opinions that may be sought or given by the ministry and instructions or orders. Fair?
Yes, that's correct.
Would it surprise you to learn, sir, that numerous personnel from the agency during your tender were referring to the letters from the Ministry of Economy as instructions and orders? Would that surprise you?
If we're not focusing here on the semantics of words, I'm absolutely sure that these were not orders, that were orders to the agency on what the agency should do. But I wish I could see the documents, if they're available here, before I make my statement on this. I believe, and from what I know, we have not had such situations.
Why don't we look at some of those documents now then? Why don't we turn first to CE 43. And again, I recognize you may not have seen this document before, and I'm happy to represent to you what it is once you have it in front of you. Okay, this is a letter, you can see at the very top, letterhead of the Privatization Agency of the Republic of Serbia. And the date of the letter is November 14th, 2014. You with me so far?
Yes, I have it, but it's a long document. It'll take me more time to read it before I can make any comments relating to the document.
I'll take you to the specific language that I think is relevant. Just to provide you the context of this letter, the ombudsman for Serbia had written to the privatization agency and asked why it had not terminated the BD Agro privatization agreement. And this letter is the privatization agency's response and explanation for why it had not terminated the privatization agreement with BD Agro. And I want to direct your attention to the second paragraph where it says, regarding the above mentioned, we would like to inform you of the following. There are several reasons why the agency did not render a decision on termination of the agreement for the subject of privatization BD Agro as follows. And picking up on the second bullet point, failure of the competent Ministry of Economy to provide instructions, doesn't say opinions, regarding further actions. The next bullet point says, standpoint of the Ministry of Economy that termination of the agreement is not economically justified. And then you'll note in the last bullet point it refers to the procedure of supervision. Do you see that?
Yes, I can see them.
And then if you look at the top of page 2, says, due to this legal situation, the ministry competent for economic affairs, so the Ministry of Economy, as I understand it, quote, was actively involved in resolving the problems of the subject privatization, and the agency sent several urgency notes to the competent ministry in order to obtain instructions. Was it common, Mr. Cvetkovic, for the ministry to be, quote, actively involved in individual privatization projects?
If I can go back to what I actually had a very short time to read some of this. My understanding of this is that at the moment this letter was sent, the supervision procedure had already started, and this definitely was very important. It had a decisive impact on the further procedure in this privatization. And in that sense, the word instruction is the word I do not understand. I wouldn't give it that much weight. It simply means that there is no need for an additional legal confusion now that the supervision had already started, and that the agency should not be complicating things further regarding this case. But as I said, I have not had a chance to read this more carefully, so I cannot give you a more detailed statement on this.
The second paragraph on that page then says the agency addressed the competent ministry for the first time with a request for instructions on further actions in the case after the meeting held on 30 March 2012 with representatives of the competent ministry. And I might note that there at the bottom of the page is another mention of a meeting held on November 2nd. This is the last paragraph. In the premises of the privatization agency, again with representatives of the competent ministry present. My question to you is, was it common for the ministry to attend meetings at the privatization agency with respect to particular privatizations?
If you could please allow me some time to find the text.
Second paragraph on page 2, it's highlighted, begins the agency.
Hvala. Hvala.
So again, my question was it common for representatives of the Ministry of Economy to have meetings at the privatization agency to discuss particular privatization projects?
I can't remember exactly, but I'm sure there have been situations where on some cases we had sometimes representatives of the ministry attending, but I can't give you a precise answer. I do not remember.
Let's turn then to the page 3 and to the last paragraph on that page. And I promise we're almost done with this document. Picking up with the paragraph in line with, the decision was made not to take into consideration the case of BD Agro before the receipt of the response of the ministry, that is the conclusion, capital C, of the government.
Da, pročitao sam.
Yes, I've read it.
I see the conclusion of the government. It seems like that's far more than just merely an opinion. Would you agree?
Teško mi je da se o ovom izjašnjam.
I really don't know what to say. I cannot respond. I can't tell you why it is with capital Z and what the intention of this letter was.
Isn't it true, sir, that the decisions made by the ministry during the supervision procedure were obligatory for further actions of the privatization agency?
It is my understanding and my understanding of the mandate of the ministry with respect to the work of the agency. It could only say whether the agency was implementing the law properly in its work and nothing more. In other words, I don't think it was possible for the ministry to communicate with the agency in any other way, except for making comments on whether the agency did something in line with the law or not.
I don't think that answered my question, sir, so I'll ask it again. Isn't it true that the decisions made by the ministry during the supervision procedure are obligatory for further actions of the privatization agency?
I'm not a lawyer, so I can't say whether the decisions of the ministry were of binding nature. I think the agency had a clear mandate, and I haven't encountered such a situation during my office in the privatization agency.
Well, this letter was issued on November 14th, 2014, so it was slightly after you departed, but take a look at the last paragraph of that letter. This is obviously very relevant to BD Agro, since its contract was terminated after this letter, and I'll read you what it says. Having in mind the fact that the buyer has not completely fulfilled his contractual obligations, as well as the fact, and now here's the key language, that decisions made by the ministry during the supervision procedure are obligatory for further actions of the privatization agency, the agency is not able to make an independent decision in this case before completion of said supervision procedure. Mr. Cvetkovic, contrary to your testimony and your witness statement that you acted independently of the Ministry of Economy, this contemporaneous document specifically says the ministry cannot act independent, agency cannot act independent, and that the ministry's orders are obligatory for further actions of the privatization agency. Correct?
I think not. I think we have here a thesis that the supervision procedure and its binding nature on the further actions of the agency refers only to the fact that the ministry has the right and possibility to check the legality of the agency's work and not to take decisions on its behalf, the decisions that are by law placed within the competence of the agency.
So you dispute that the Ministry of Economy's instructions were binding on the agency, do you?
Again, in my mandate as the director of the privatization agency, I did not encounter such a situation. And given that the letter we are discussing here were made and exchanged between the ministry and the agency at a time after I left the agency, I now can't give you my opinion on the circumstances that led to these formulations.
Testimony of Serbia's witness that appeared before you, Ms. Vukovic, the chairman of the commission, including during the time you were director. If we could pull up this morning's transcript, page 78, line 23. line 23. Starting on line 22, you may see, actually we'll start on 23 with the words, "my understanding." This is Ms. Vukovich's testimony to the tribunal earlier today. Quote, "My understanding of all the decisions issued by the line ministry were that they were generally speaking binding on the privatization agency, and this is how we acted in all privatization proceedings where oversight was conducted over the agency, and there were quite a few before this case and after this case as well." Isn't it true, Mr. Svetkovich, that the personnel at the privatization agency, including personnel while you were director, considered the instructions from the ministry to be obligatory, which we just saw from the letter I showed you, and binding, which we just saw as an admission from Serbia's witness earlier today?
I'm sorry, Madam President. We would like to object. I think that we have a line of questioning where the witness is asked about what is binding, what is obligatory. The witness has given its point of view, and now I think that this is pushing it into a definitive position on the legal question. And then his statement is contrasted with the statement of a lawyer, which was Mrs. Vučković today.
So these are all fact witnesses. I mean, even Mrs. Vuković, who has a legal background because she has a bachelor in law, was heard as a fact witness. I understand these questions to turn around the witness statement. In paragraph 5, it says, in accordance with the law, the PA was making decisions independently. So if I make a decision independently, it means that I'm not bound by someone else's decision. And I understand that this is what is being tested now, was the understanding of others within the agency. I think that's fine, frankly.
Okay. I'm happy to move on. At paragraph 4 of your witness statement, and this is another paragraph to which you referred earlier, you stated that the agency was independent and had the capacity of a legal person. It had its own bank account and budget. You see that?
Yeah.
And
Yes, I do.
resources for the PA's budget came from its own revenue, which the agency due to its independence and ... Do you see that?
Yes, I do.
Initial budget for the agency came from the government of Serbia, correct?
I cannot either confirm or deny this because at that time I wasn't employed at the agency. But I believe that under the law, the agency had the possibility of filling its budget from donations, subsidies, and there were other possibilities of filling the budget. And I assume, and to the best of my recollection, I think in that period, donations too were used at the beginning of the work of the agency. But in any case, I cannot comment on how the first budget of the agency was filled and created for it to start operating.
Fair enough. I accept that you don't know where the initial budget came from, and we'll again leave it to the Serbian law lawyers to discuss that. With respect to the proceeds and where they went, after a commission was kept by the commission, or by the agency, the proceeds you received had to be handed back over to the state budget, correct?
Ja bih bio precizniji.
I would be more precise there. The agency kept part of its commission fee that it was entitled to under the law, and the privatization proceeds were transferred either to the state budget or to other owners whose capital assets was sold, and the distribution of the revenues was in accordance with the law, and the percentage kept by the agency was also defined by the law.
Do you acknowledge at least a portion of the money that was received as a result of the privatization was put back into the state budget?
Većina.
Most of the money ended up either in the budget if it concerned socially owned capital, and some other part was distributed to owners if there were some minority shareholders. It all depended on what was subject to privatization in a given case.
And I'd like to talk for a minute then about what happened when there was a termination of a privatization agreement and how the shares were transferred back to the privatization agency. Again, just according to your understanding. First of all, just very approximately, while you were director, how many terminations of privatization agreements were there? 5, 10, 50, 100? Just a general number.
Really, a lot of time has passed since, and it would be difficult for me to give you an exact figure, but certainly it was a 2-digit or 3-digit number of terminated agreements.
When an agreement was terminated, the shares would then be returned to the privatization agency, correct?
Yes, they were returned to the privatization agency.
The procedure by which the agency would do that is that it would issue a decision to terminate and then order the Central Securities Depository to transfer the privatized shares to the agency, correct?
According to my recollection, yes, there was a similar mechanism, but I couldn't give you a precise answer.
What is there was no court procedure before the shares were transferred back to the privatization agency. It was something that the Central Securities Depository did automatically based on the unilateral order from the privatization agency, correct?
I wouldn't say it was only an order of the agency. It was the letter of the law that stipulated that this was the procedure after a terminated agreement. This wasn't the discretion of the agency to decide on this.
Mention the law, let's just note it for the record. Let's go to CE 254. Article 56. Is that the legal provision to which you were referring? And for the record, this is the business rules of the Central Register Clearing and Depository of Securities.
Da, ja nisam
Yes. I haven't read this text before, and I cannot comment, but what I referred to was that once an agreement was terminated, the agency disposed of the shares. That is, they were transferred to the agency. My comment had to do with that, not with these rules for the operation of the central depository.
Whether a private seller of shares would have been able to achieve return of the shares if it terminated a share purchase agreement with a buyer without going to court first? Again, if the answer is you don't know because you're not a lawyer, that's perfectly fine.
I do not know the answer, but I think that court proceedings were the only possibility.
For a private party?
Za privatnu stranu, za privatno lice. I apologize. Then, what was your question? Sorry.
Said, I think that court proceedings was the only possibility, and my question was if the seller was a private party. That's what you were referring to, sir?
Da, moje nerazumevanje vaše...
Yes. Why I didn't understand your question was because it wasn't clear if you asked about the agency and its actions, or hypothetically if there was a case between two private parties. That's why I didn't understand your question. We are talking here about the agency agreements.
Make sure I understand it. I'm afraid the transcript may have gotten a little confused, and perhaps it's my fault. Your understanding is that if the privatization agency terminates a privatization agreement, that it can obtain the shares back unilaterally without having to go to court first. Correct?
Odgovor je da ne.
The answer is no. The agency could not return the shares to a buyer without going to court.
Did a legal provision, which I think it stated the opposite. I understand you're not a lawyer, but your prior testimony was the opposite.
Now, I wonder whether there's not a misunderstanding. Do I understand you correctly, sir, that you say no court proceeding is required for the shares in a privatization agreement with the privatization agency to be returned to the agency in case of termination?
Zakon je...
The law stipulated that once an agreement was terminated, the agency would transfer the shares to its ownership. That has been clear from my statement so far. It wasn't clear whether the question had to do with the agency having the right to return the shares to the previous owner. And it didn't have this right.
Was a different one, was a hypothetical in case there is a share purchase agreement between two private parties. Does the seller, when it terminates the agreement, recover the shares without going to court? And I understood you there to say no, a court proceeding is required. Now, if I misunderstood you, you will correct me.
Izvinjavam se. Da, izvinjavam se.
I apologize for this misunderstanding. The question was a hypothetical one, whether in some other situation where there are two private parties that are contractual parties, whether one party can return the shares to the other party. I think this is beyond my knowledge of the law of contracts and torts in Serbia and my general knowledge of these rules.
Were you aware, sir, that during your tenure as director, the privatization agency was sued in a ICC, an International Court of Arbitration proceeding concerning the Uniworld privatization?
To znam samo...
I do not have any broader knowledge of this. I only have anecdotal information. I knew that there was a dispute where one of the parties was a company called Uniworld.
Now, at the outset, you had noted that after you left the privatization agency, you went to work at PwC, correct?
Tako je.
Yes, correct.
Privatization agency worked on a number of projects together during your tenure, did they not?
During my tenure, you mean my tenure at the privatization agency?
Of the agency.
Ne, bio sam. Po mom saznanju,
According to my knowledge, before I was employed by PwC, PwC had worked on some projects with the agency, but other than this anecdotal information, I had no knowledge on those projects.
Approximately how many different projects during your tenure as director at the agency did PwC work on? Just approximately.
ne znam.
I don't know. I really don't have that information. I don't remember.
Would 30 or so sound about right?
Ne znam.
I don't know. I don't think so. But I don't know. I can't remember.
But you nevertheless felt it was appropriate to go work for PwC immediately after leaving the agency, that there was nothing improper about that, correct?
Tako je.
Correct.
It's quite common for government employees to leave the government and go work for private parties, private companies with which they had worked while in government. Isn't that true?
Mislim.
I don't think that this is some kind of practice, but in any case, this is not what led me in my decisions, because both before my work in the agency and after that work, I did similar jobs. Before my work in the agency, I was a consultant in projects that were funded by international donors, and I was a consultant at Deloitte. That's my profession.
Agree that there's nothing suspicious about a government employee going to work for a private company after leaving government, even if while in government they worked for that company or worked with that company. Correct?
My post of director of the agency for privatization was not a post of civil servant. I took it over after a public competition. I performed professional duties, and I don't believe these two things that you are mentioning here are linked in any way.
To me, there's nothing suspicious about a government employee going to work for a private company after he or she leaves government.
I'm sorry, Madam President, I have to object because I don't see any relevance with this question.
Yeah, I think we understood that this was the way your career evolved, and
I mentioned the
that's it,
point.
unless you can explain to us why it is relevant.
Well, I mentioned the point because there have been allegations against certain employees of BD Agro that it was improper for them to come to government after they left their relevant post. And what I was trying to establish is there's nothing inherently suspicious about a government employee that later takes a private position.
Well, we can assess this. We know that this is what occurred was Mr. Svetkovic.
Okay. I'll move to a different topic. At paragraph 7 of your witness statement, you stated that you visited BD Agro, the farm, in 2007, correct?
To je paragraf 11.
That's paragraph 11.
The correction. And you say there that you met Mr. Obradovich. You see that?
Yes, I do.
Did anyone else accompany you on that trip?
Ne sjećam se tačno.
I do not remember exactly the composition of the delegation, but this was a delegation that included several persons from the Privatization Agency and other institutions, and I cannot remember who were all the people who were there with me, but the delegation was rather large and broad. Yes, I mentioned this in my statement as the moment when I met Mr. Obradovich.
And I understand from paragraph 11 that you say that while you were aware of the BD Agro privatization, you visited the farm, at least on one occasion. You generally can't remember many other details about that particular privatization because you had so many other privatizations with which you were concerned at the time. Is that a fair characterization?
Da,
Yes, just as it says in my statement, it was one of many visits that I had to take, so there wasn't any particular difference between this visit and other visits that I had to make as an employee of the agency.
But you were aware, were you not, that the buyer of the BD Agro had pledged the shares in BD Agro to the privatization agency. You were aware of that, correct?
I have clarified the circumstances when I first met Mr. Obradovich in 2007, when I was the deputy director and when I didn't have a more active role in the commission in charge of taking measures. So this part of my statement relates only to my first recollection of BD Agro as a privatized entity.
Sir, it was whether you were aware that the buyer of BD Agro had pledged the shares to the privatization agency.
Back then, I did not know that. It was just not something I had to deal with.
Are you familiar with the privatization agency's rule handbook? Or were you at the time?
Ne znam na koji se pravilnik odnosi vaše pitanje.
I'm not sure which rule book you're specifically referring to.
763. And section 9.5, which is, I think, on page 5. And I'm going to pick up, just to avoid reading the entire paragraph, in the second line from the bottom of the first paragraph. The entity being privatized has been paid in full. It's referring to the center shall draft a decision removing the pledge from the shares/shareholdings. So this is a provision from the Privatization Agency's Rule Handbook, paragraph 9.5. Do you see that?
Da.
Yes, I can see it.
And during your tenure at the Privatization Agency, did the agency follow this rule?
Budući da
Well, in my capacity of director of the agency, I was in charge, I was responsible for all of the activities of the agency. I cannot tell you, however, whether the center itself adhered to this, because the center itself had its professional management and they had rules for acting, defined rules for acting. I cannot state much about anything that relates to the work of the center or Department for Control, because they were working in line with the Job Descriptions Act. I believe that all of the employees of the agency did a conscientious job.
E33. This is a letter from the Ministry of Economy dated May 30th, 2012, in which it concluded that there was no economic justification to terminate the privatization agreement with BD Agro. And my first question to you, sir, is have you ever seen this letter before?
zaista je prošlo puno vremena.
A lot of time has passed and I've seen so many letters, so I cannot say with certainty that I've seen this, but okay, never mind, I have it here in front of me. You can ask whatever you want to regarding this one.
Were you made aware at the time that the Ministry of Economy had concluded that there was no economic justification to terminate the BD Agro privatization agreement?
Sećanje da smo mi
From what I remember, the commission in whose work I took part was discussing everything related to the actions taken by the agency, and naturally all of our activities were focused on those circumstances. According to my understanding, this is an opinion on economic justification, whether it exists or not. And the ministry is the one that makes an assessment from an economic point of view and from a broader point of view. But this letter as such is not specifically relevant for the actions of the agency. It's just one in a series of opinions that we will get in order to take our decision.
Made aware of this letter from the ministry at the time? Did it make it to your desk?
I really do not remember that.
Where I'll have the same question, which is CE34. And I will represent to you, sir, that this is a legal opinion from the law firm Obradovich, dated June 12, 2013, where the agency was seeking advice from outside legal counsel on whether it could lawfully terminate the privatization agreement with BD Agro. And I'll just direct you to two passages and then ask you my question. The first is on the third page, the words accordingly, or according to. It'll be highlighted for you on your screen. The law firm concluded, according to the agreement itself, the agency did not have the right to terminate the agreement due to violation of obligation referred to in Article 534, because this is not stipulated as a reason for termination. You see that?
U redu, pročitao sam.
Fine, I've read this.
End of the legal opinion, last paragraph, first two sentences. Based on all of the above, we conclude that besides the fact that there is no economic justification, there is also no legal basis for termination of the said agreement on sale of socially owned capital. And then it goes on, if the agreement is still terminated, we believe that the buyer's success in a future legal procedure would be almost certain. Mr. Cvetkovic, this is a legal opinion that is describing the buyer's success in a future legal proceeding as almost certain. In view of that, I would expect this legal opinion, or at least knowledge of it, to have been made aware of you while you were director of the agency. Was it made available to you or known to you at the time?
Well, first of all, I would like to say that this legal opinion, just like all opinions, is a point of view of a lawyer, or I would say a group of lawyers which have signed this document, and that the agency was entitled and it had the possibility to seek opinions from all relevant professionals, from anybody else. So that's one thing. It's an opinion. It's not binding. It's not a binding position of any party.
I'll ask it again. Sorry, go ahead.
It's not a problem. Repeat your question. I can be more precise in my answer.
Legal opinion came in from outside lawyers that stated the buyer's success in a future legal procedure would be almost certain. I would assume this would be a matter of significance to the agency such that you would have been made aware of it at the time. Were you made aware of it at the time?
Well, my awareness of all the activities took part, actually happened by being by participating in the work of the Commission. All of the requests for opinions and consultations sent by the agency were sent by our services. We had very good lawyers within the control department, within the legal department, who, as I believe is the case in other legal matters, sometimes felt the need to seek an external opinion, to get an outside opinion. But my awareness of these matters existed only when, in the procedure of judging whether the requirements from the agreement were met or not, the case would reach the Commission, the level of the Commission. And if the minutes said that the relevant service of the agency asked for an opinion, then for sure me and the rest of the colleagues within the Commission had to become aware of that. So such letters could be sent routinely by various professionals from the agency. They wouldn't necessarily land on my desk. So I would get acquainted with such opinions sometimes in my capacity of a member of the Commission. But in any case, our professionals within the center, within other services, were able to ask themselves for such opinions.
Correctly, it sounds like you were generally aware of it through your activities and work participating with the commission. Is that fair?
The way I understood it, and you will correct me, I did not understand that there was a specific answer with respect to this legal opinion, but that Mr. Cvetkovic said that if a legal opinion would reach the Commission, then would be discussed there, then he would be aware of it. And I did not understand. Do you remember being aware of this very opinion or not?
Okay, for the sake of clarification, I really could not remember now if this has been submitted to me or not. What I clarified is that employees of the agency requested this opinion to be issued by external parties, and as such, it was probably included in materials which was submitted for the meetings of the Commission, and that there was a possibility for us as Commission members to be acquainted with it. So it was the technical and professional services of the agency that were requesting such opinions and obtaining such opinions. Whether this particular opinion was mentioned in one of the materials at the level of the Commission or not is something that I cannot recollect. It's very important, however, that all minutes from all meetings of the Commission, all decisions, have been recorded very precisely at the agency. So I believe you can find the answer to this specific question in the minutes of the work of the Commission.
I raise the matter, Mr. Cvetkovic, because in paragraph 9 of your witness statement, you state, quote, "It can be said that the privatization agreement practice a policy to keep privatization agreements in force as much as possible." And we've just seen a letter from the Ministry of Economy stating that there was no economic justification to terminate. We've now seen a legal opinion stating that there is no legal basis to terminate. And in addition to saying that the buyer's success in the future legal proceeding would be almost certain, it says, besides the repayment of the full sale and purchase price plus appropriate legal default interest, the buyer of capital would also have the right to request and get compensation for all damages. It would seem there are very good reasons to keep this privatization agreement in force. And so when you state in paragraph 9 that you had this policy to keep agreements in force as much as possible, given these two documents, how do you explain that the privatization agreement agency nevertheless terminated?
I believe that these two things are not mutually colliding. I would say that the statement that I made is completely true. The Agency for Privatization acted in such a way that it attempted to keep all agreements in force, with the exception of those cases when we would analyze the developments regarding the execution of agreements and decided that we had to terminate them. we were giving so many additional deadlines to the buyer to give them a chance to correct the irregularities and to make sure the agreement stays in force. And that's what I say in paragraph 9 of my statement. The agency always intended to keep all agreements in force. That was the best thing for the Serbian economy. That was our competence. Otherwise, if we hadn't acted that way, the agency could have terminated not just one but many other agreements much sooner, but that's not something we wanted to do. It was our policy to keep in force the agreement as much as possible, and that can be seen through numerous additional deadlines. But when you see, even though that you've given so many additional deadlines, that there's no progress, then certainly the agreement has to be terminated. So I believe these two things are not mutually conflicting. I would also underline that consistency in actions taken by the agency always existed. All of our buyers knew what it is that they had to rectify, and all of them were given numerous chances to do that. The agency has never terminated any agreement without using all possible chances to rectify the irregularities.
You just noted a number of times that there were deadlines given to the buyer, correct?
Exactly.
And in fact, you authored a number of the letters to the buyer, giving the buyer deadlines, didn't you, sir?
I did not draw them up myself. Support services would normally draw them up, the sector that was responsible for this kind of work.
Sign them.
Potpis na kraju.
That is correct. I would sign them.
One of them, which is CE 96. And I just want to review what you told the buyer that the buyer needed to do to avoid termination. First, let me identify the document for the record. It is a letter from the Privatization Agency of the Republic of Serbia dated June 24th, 2011. And can you confirm you are the signatory on this document?
Da, to je moj.
Yes, that's my signature.
And if we go back to the beginning, you'll see that you grant the buyer an additional 60 days as of the receipt of this decision, and then it gives them a number of things that the buyer needs to do to comply. Fair?
Allow me a moment to read it carefully, please. Okay.
U redu, izvolite.
It's okay. You can start asking questions.
So if we start under the highlighted language with the dash, the first thing you informed the buyer that it needed to do was comply with Articles 533 and 534, correct?
Tako je.
Yes.
Do you have an understanding of how the buyer could have possibly cured the alleged violation of Article 533?
I'm not sure I fully understand your question. So how could the buyer remedy the breach, or what exactly did you mean? Could you please clarify?
Do you even recall what the alleged violation of Article 533 was?
At this moment, I do not recall what exactly these refer to, but I'm absolutely sure that the buyer was informed exactly about the obligations that he had. The buyer normally knows the agreement very well, but I would need to go back to the agreement and see what these two refer to. That would be beneficial. But what I'm trying to emphasize is that the buyer was aware of the contractual obligations. He received information on this in writing, and then because auditors were hired, he knew exactly what the obligations were. So in that sense, I'm trying to say that the buyer knew perfectly well what the letter of the agency referred to.
And you understand from the very last paragraph of this letter that if all of the conditions that are laid out on pages 1 and 2 of this letter are not satisfied, quote, the privatization agency will undertake the measures under Article 41A of the law on privatization. You were effectively stating that unless all these conditions were satisfied, the privatization agency would terminate the contract, correct?
According to this, we are ordering the buyer to remedy all the violations that we had established, and we were granting him additional deadline by which to rectify the violations.
And all of these conditions had to be satisfied, not just one of them, correct?
All the conditions need to be fulfilled for the buyer, for the agency to state that the buyer had fulfilled all his obligations. But as I've just explained in my reply, the agency was the one who assessed whether the buyer continued to be a bona fide buyer by meeting at least part of the contractual obligations to an extent where he would appear to be a bona fide buyer. And even if he did not meet all the contractual obligations, this does not mean that soon after that the agreement would be terminated.
Trying to establish is that of all the conditions on here, your expectation when you signed this letter was that the buyer had to satisfy each and every one of them, and if it didn't, then the privatization agency would terminate the contract. It wasn't a matter of just satisfying one. The buyer had to satisfy all of them, correct?
So we are not talking about an automatic procedure. So the agency would not terminate the agreement automatically. Instead, what we have here is the list of conditions that he was presented with and the deadline by which he was supposed to remedy the breaches.
Mr. Svetkovic, I have 4 or 5 other letters. I think we can just skip them all with a simple answer to this question. Did you ever tell the buyer that if it only returned the money given to Inex or Sergveni Signal, then the agreement would not be terminated, and all these other conditions didn't need to be satisfied? Did you ever tell the buyer that?
I can't say. I did not say so to the buyer. I don't think something of this kind could be communicated to the buyer by anyone from the agency. And the reason for this is that all communication with the buyer happened through formal letters. So I don't think one failure I think that one breach was ever posed as the only condition for the termination. I don't think this was possible.
Madam President, I have no further questions.
Thank you. Any questions and redirect?
No, Madam President, thank you.
No. Do my colleagues have questions? Let me see whether I have questions that have not been asked so far. You were the deputy director from May 2007 to June 2009, and then you were the director of the privatization agency from June 2009 until November 2013. Is that right? During this time, about how...
That is correct.
Thank you, sorry. During this time, about how many privatization have you overseen?
U periodu
During my tenure as deputy director, I, formally speaking, was not involved in the supervision. As a deputy director at the time, I did some other work relating more to the preparation of the privatization.
Maybe I didn't formulate this right. During your time, how many privatizations did the agency handle?
It's difficult to come up with a precise figure because we had a really big number of different privatizations. But we are speaking about hundreds.
What is big?
sasvim sigurno,
in one stage or another, so including preparation stage, supervision of procedures, I think we are speaking about 300 to 500 of different privatizations, but I'm giving you a rough figure that I'm now giving you from the top of my head. So this was the rough figure, but we were addressing a large number of privatizations. During my office, the agency handled even more privatizations, I believe. But if we're talking about what privatization procedures I worked on more intensely, or the privatizations I had more knowledge about, then we are talking about several hundreds. And the total number of privatizations that the agency handled was much, much bigger.
How big was that? Approximately?
Pa agencija je...
During its work, the agency privatized somewhere between 2,500 and 3,000 companies.
How many, what's the percentage of terminations of privatization agreements on these 2,500 to 3,000? Do you have an indication of that?
If I remember well, the number of terminated privatizations ranged in some varied from one period to another, but I think from 1/4 to 1/3 was terminated at one period of time.
Smatrali su se neuspešnim privatizacijama.
They were considered unsuccessful privatizations. Why is it difficult to give you figures? Because some companies were re-privatized or privatized for the second time, and then it would happen that the second privatization was successful. Some other companies sold their assets. That's how they were ended. So it's difficult to give precise statistics on this.
You say something like 25 to 30%, I understood you to say. 1/3 to 1/4 would fail, and
Po mom najboljem sećanju, da.
To the best of my knowledge, yes. But I think it's can be made available officially. I'm not sure my memory serves me right please understand if my figures are not precise.
To have an idea, it could have been 5% or 50, and that there's something in between. Thank you. I have no further questions. So that ends your examination. Thank you very much, Mr. Stajkovic, for your answers.
Hvala vama, gospođo predsjednice.
Thank you, Madam Chair, and thank everyone.
Now we will, I think we should take a break because we have been going for quite a long stretch, especially for the interpreters and the court reporters. It's been long. Let's resume in 15 minutes from now, and so the next witness is Mr. Stefanovic, is that right? Suppose so. Nobody says no. Good. Good afternoon, sir. Do you hear the interpretation when I speak?
Da.
Yes, I can hear it. Thank you.
You are Dragan Stevanovic.
Tako je.
That is correct.
You are Secretary of State at the Ministry of Economy, and you have held this post since 2014. Is that right?
That is correct.
And before that, you were a president of the Commission for Public-Private Partnership. Is that right?
That is correct, and I'm on this position today too.
Oh, you still have this position, yeah. That's right. I didn't read my notes well. Apologies. You have provided us with one written statement dated the 23rd of January 2020.
Yes.
You're heard as a witness. As you know, you're under an obligation to tell us the truth. Can you please read the witness declaration that should be on the table before you?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So I first turn to Mr. Jerish, or yes?
Thank you, Madam President. We have no questions at this time. Thank you.
Good. Then Mr. Mijatovic.
Thank you, Madam President. Good afternoon, Mr. Stevanovic. My name is Luka Mišetić, and I will be asking you a few questions on behalf of the claimants. Before we get into the substance of your witness statement, first, could you tell me in what month in 2014 did you become the State Secretary in the Ministry of Economy?
I think it was the first half of the year, maybe May or June. The first half of 2014, definitely.
Okay. And the Commission for Public-Private Partnership, is that, can you tell us what that is?
It is the government's commission addressing public-private partnership projects. It approves such projects.
Okay. And this commission is at the level of the government, or is it within a ministry?
Public-private partnership is within the competence of the Ministry of Economy, and the commission was set up by the government's decision.
Okay. At paragraph 6 of your statement, you state that, quote, Mr. Rand was interested in assigning the agreement on privatization of BD Agro dated 4 October 2005 by having the privatization agency conclude an agreement on assignment of the privatization agreement with his company, Koropi. It's your position, is it not, that only Mr. Obradovich, as the nominal owner, could seek to assign the privatization agreement, correct?
Yes, the assignment could be sought by anyone. But Mr. Obradovich was the owner and he could seek that.
Well, the assignment was seeking to assign rights that he had in the privatization agreement, correct?
Can you please repeat your question? Thank you.
It was Mr. Obradovich who was the nominal owner in the privatization agreement, correct?
That is correct.
Okay. You continue on in paragraph 6. You say, in that regard, several meetings were held in the Ministry of Economy during 2014 and 2015. These meetings were attended by Ms. Neda Galic and I for the Ministry of Economy, Ms. Julijana Vučković for the Privatization Agency, Mr. Aaron Braško, and attorney at law Slobodan Doklestić for Mr. Rand, and as well as Mr. Igor Markicević, who was the then director of BD Agro. Now, at none of these meetings did Mr. Obradovich attend the actual meeting, correct?
He was invited to one, but unfortunately he did not stay in the meeting.
Okay, so to the best of your recollection, Mr. Obradovich never attended one of these meetings where the assignment of the agreement was discussed, correct?
No, he didn't.
And no one representing Mr. Obradovich attended any of these meetings, correct?
No, Mr. Igor Markicevic was there. He was the director of the company that was owned by Juro Obradovich.
Well, Igor Markicevic was not Mr. Obradovich's personal representative, was he?
He was the director of the company BD Agro.
That's correct, but you never saw a power of attorney or some other written document authorizing Mr. Markicevic to act on behalf of Mr. Obradovich, correct?
I did not request that. I don't think that was necessary.
Well, we'll get to that point in a moment. From the 1st of January 2014 until the privatization agreement was terminated in October 2015, how many meetings did you have with Mr. Obradovich?
With Mr. Obradovich, I had one meeting. Oh, I can't remember. My colleagues from the Ministry of Economy, from my office only.
What are their names?
I think we had Ivana Janachkovic.
And were any notes taken of that meeting?
No.
Is it usual for the state secretary to have a meeting with a an owner of a privatized entity and no notes be taken?
Minutes can be taken, but they needn't be taken.
That there would be no notes taken at this meeting that you're referring to?
Because I was the one who chaired the meeting.
Why did you decide not to take any notes of your alleged meeting with Mr. Obradovich?
I felt this was not important.
That the meeting was not important or that the notes were not important?
That minutes were not important.
Minutes not important.
Because I assessed that it wasn't important.
Why did you assess that it wasn't important?
Because the topic was not so important as to require keeping of minutes.
The topic?
We discussed a loan from the development fund.
You don't think it was important to take notes of someone asking for a loan from the development fund?
I believe that it wasn't important.
If we look at Exhibit CE 769, I just want to show you a document and see if you were aware of the information that's contained in it. Now, if we go down to the last email, please. This is an email. Let's see. Sent to the Minister of Economy, dated, let me see, December 18th, 2013, and it had a letter attached, and if we could take a look at the letter. It's signed by Mr. Milan Kostic. Do you know who Milan Kostic is?
No.
No, I don't.
Okay. In the letter, in the first paragraph, Mr. Kostic writes to the minister, requesting a meeting for Mr. Aaron Brashko, who would like to collect sufficient level of information for the purpose of furthering the development plan of the company and inform Mr. William Rand from Canada, who is a majority owner of BD Agro. Do you see that?
We do.
Yes, I do.
Were you ever informed by the minister of this information that William Rand was the majority owner of BD Agro?
No.
No, never.
If we could turn to paragraph 8 of your witness statement. This is the meeting of the 15th of December 2014, at which you asked Mr. Obradovich to leave the meeting. You say that when Mr. Rand's representatives showed up at the meeting, they were dissatisfied with the fact that Mr. Obradovich was also present, so they asked that Mr. Obradovich leaves the meeting, having in mind that this meeting was not actually scheduled upon the buyer's initiative, but upon the initiative of Mr. Rand's representatives. We asked Mr. Obradovich to leave the meeting. Which of Mr. Rand's representatives asked that Mr. Obradovich leave the meeting?
I think it was Mr. Broshko.
Sure.
I know for sure that it was him.
Now, you mentioned before that I asked you whether any representatives of Mr. Obradovich attended these meetings, and you mentioned Mr. Markicevic. Did you find it unusual that the owner of the company was being asked to leave, but the director was allowed to stay?
Yeah.
Yes, it was.
Were you made aware prior to this meeting that Mr. Brashko, 11 months earlier, had told the privatization agency that the privatization of BD Agro had been conducted with Mr. Rand's money?
No.
No, I don't have that information.
Aware that Mr. Brashko, 11 months prior to this meeting, informed the privatization agency that Mr. Rand had entrusted Mr. Obradovich with acquiring BD Agro?
No, I wasn't.
Now, if we can take a look at the notes of the meeting, which is Exhibit RE 38. Number 1, it records you as being present. And in line 9, Mr. Markicevic is present, and line 10 is Mr. Brashko is present. If you could take a look at the description of the subject of the meeting and read it to yourself, please. It says in the first sentence, the reason for the meeting was to present to the Ministry of Economy the factual findings about the entity of privatization, BD Agro, Dobanovci, in order for the ministry to take a position on the subject of the completion of the procedure of supervision over the work of the privatization agency in the subject case. Do you see that?
Yes, I do.
Presented the factual findings to the Ministry of Economy at that meeting.
I really do not remember. Who spoke?
The next sentence says, the representatives of the entity of privatization have committed to prepare for the next meeting, which is agreed in principle to be held on the 17th of December 2014 in the ministry, the materials on the state of mortgages registered on the property of the entity undergoing privatization as a collateral warranty for the liability of third parties. Do you know which specific representatives committed to preparing those materials for the next meeting?
I really do not remember that. It was a long time ago, and I really cannot say that.
Okay. You never attended a meeting with Mr. Obradovich after this meeting to discuss his views on the assignment, correct?
I have just said that I had one meeting with Mr. Obradovich, and it did not concern the topic we are discussing here today. I apologize. Could you please repeat your question? Was it only about me having a meeting? Could you please repeat your question?
This meeting, did you have a meeting with Mr. Obradovich to discuss the assignment of the agreement to Koropi?
No, I did not. I had one meeting with Mr. Obradovich. We did not discuss this topic at all, and I never saw Mr. Obradovich after that.
Testified that you had a meeting regarding a loan from the development fund. Were you involved with the development fund at the time of your alleged meeting with Mr. Obradovich?
No, I wasn't.
I'm not sure I understand. You were having a discussion with him about a loan from the development fund, even though you weren't involved with the development fund at the time of the meeting, correct?
Yes, you understood it well. That's what I said.
All right, Madam President, I don't have any more questions. Thank you very much.
Thank you. Do we have any questions in redirect?
Again, thank you for your patience. We do not have any questions.
Thank you. Do my colleagues have questions for Mr. Stefanovic? Yes, please.
Good afternoon, Mr. Stefanovic. I would like to know in which capacity Mr. Obradovich requested you the meeting you have with him.
Mr. Obradovich requested a meeting as a businessman. Since he had a loan, that's what I learned then, from the development fund that he had not repaid in time, he requested a meeting at the Ministry of Economy to discuss this topic. As a good host, I organized this meeting as any other meeting. We discussed this with him in his capacity as a businessman.
My second and I think last question is the following. You mentioned that the origin of the meetings you had with Mr. Broshko and Mr. Markicevic was a request from the Canadian Embassy. Could you elaborate a little bit more about this? How was the request made?
Yes, that's correct. The first meeting organized with the representatives, or rather potential Canadian donors or Canadian nationals, was organized at the initiative and request of the Canadian Embassy. I do not remember precisely whether the Canadian Embassy had sent this invitation to the minister and the minister delegated this to him, or whether I had received the invitation and informed the minister that we would see them. But all meetings held with the representative of Rand Investments happened at the initiative of the Canadian Embassy, and each future meeting that we held came at the initiative of the Canadian nationals. In their words, the topic was the assignment of the BD Agro Privatization agreement from Mr. Juro Obradovich to Mr. Rand. As good hosts, we organized the first such meetings and all the other meetings. My mission was to bring to the table all those who were relevant and who had the responsibility for this procedure. And they couldn't expect me to resolve this issue, but my role was to bring there all of those who were responsible for this. Those were my colleagues from the ministry, from the privatization department there, as well as the people from the privatization agency. They discussed this. If you ask me about my view, I had nothing against this personally, against this assignment of the agreement. Unfortunately, the conditions were not in place in line with the law, and this transaction never took place. This was the view of my colleagues from the Ministry of Economy, and this was the view of the privatization agency. Respecting their views and relying on those views, we had the outcome in this case that we had, and that's all I can say.
After the first meeting, did the Canadian Embassy inquire about the outcome of the meeting or later on?
They didn't ask me, they didn't contact me.
Thank you. No further questions, Madam President.
Thank you. I think all my questions have been asked, but I would like just to go back to your witness statement, paragraph 8, about the 15 December 2014 meeting. If I understand you correctly, you considered that Mr. Obradovich was the buyer and he was the owner of the BD Agro shares. And the topic of the meeting is the assignment of these shares. And the attendees whom you call the Rand representatives, specifically Mr. Broshko, ask you to ask Mr. Obradovich to leave. And somehow, and you do it. But it's strange to me because if you really considered that this was the owner and meeting is about his property, why did you not say he can stay, or I don't understand why he should leave? Why do you, with the understanding you had in mind, ask him to leave?
Our understanding on whether he should be present there or not was reflected in the fact that we had invited him to the meeting. If you ask me personally, and also in that capacity that I had at the time, I really believe that it was his place to be there, and that was in the interest of those who wanted to take over the agreement. That was in their interest too. The meeting was organized at the initiative of Canadian businessmen at their request. It was not pleasant, but I asked Mr. Obradovich to leave the meeting. What was important to me was that on my side of the table, I had the people that were responsible for this business, and those were people from the Privatization Agency and my colleagues from the ministry. And essentially, his presence or absence could not change anything there. They had to resolve their relations with the Privatization Agency and meet the conditions that they were obliged to meet under the law, and I think the transaction should have happened. I think they made a mistake in asking Mr. Obradovich to leave the meeting, but this showed their mutual relations. It could be felt that there was a problem there. What, I really don't know, and I didn't want to deal with that. I organized the meeting at their initiative. At their request, I asked Mr. Obradovich to leave the meeting, but I believe that was an omission on their part and not on my part. I only acted as a good host.
When you organized the meeting, was it your initiative to invite Mr. Obradovich?
Yes. Yes, I was of opinion that he was supposed to be there since he was the owner, since the agency had concluded the privatization agreement with him, and he would have to take part in the transaction. Had we gone through with the signing the agreement itself, so he's the owner, he's the buyer, and therefore we were of opinion that he needed to be invited to. Actually, I understood that that was my mission in this entire transaction, but the Canadian party decided that it should be otherwise. I have complied with their request, and all meetings that they requested me to organize was organized in the best way possible. We were of opinion as representatives of Serbia to be good hosts and to treat our Canadian guests properly and to leave a good impression. We did our best to leave a good impression. I don't know what were their expectations. I will not discuss that, but the precondition for the transaction to be effectuated was for the requirements under the law to be fulfilled. I was told by my associates and by the staff of the privatization agency that it did not happen. Therefore, the transaction couldn't have been effectuated.
Thank you. No I have no further questions, so this ends your examination. Mr. Stefanovic, thank you for your assistance.
Thank you very much.
So should we, now it's a little past 4. I think it would make sense if we hear the next witness who's the first expert, actually. Are we all in agreement with that?
Yes, Madam President.
Yes, Madam President, but we suggest a short break of 5 minutes so we can
Yeah, sure, we could
organize ourselves, or 10 minutes.
get organized. Let's just take 5 minutes to switch witnesses, and then we'll restart. Sure.
Yes, I've seen that. Yeah.
Can I keep it
That's,
here, or-
I
you
have
have
it
it there?
here. Yeah, thank you.
Are we ready to go? Good afternoon. Now I will try to pronounce your name correctly. I hope I can manage. How do you, well, maybe I ask you, can you please state your identity?
Yes, Madam President, I am Bojana Tomic-Brkušanin. You can just say Tomic or Bojana.
Tomic, and how do you spell your first, how do you pronounce your first name?
Bojana.
Like a Bojana, yeah, good. And I understand that you will testify in English, is that right?
Yes, that is right.
Good, thank you. You are currently and since May 2019 regulatory officer in the Foreign Investors Council, is that right?
Well, since last August, I am now CEO of Digital Serbia Initiative. So I now work in different business association, but it is also a business association of some of the largest Serbian IT companies.
Thank you. And before the Foreign Investors Council from 2012 to 2019, you were holding various positions in the Securities Commission.
Yes, that is right.
Thank you. You have handed in 2 expert reports. The first one is dated 3rd of October 2019, and the second one 5th of March 2020.
Yes, that is right.
And as you know, you're heard as an expert. As an expert, you're under an obligation to make only statements in accordance with your sincere belief. Can you please confirm that this is what you will do by reading the expert declaration that should be on the table in front of you?
Yes, I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. So I will first turn to, sorry, I got used to turning this way, but that's a mistake, to the Claimants Council, please.
Thank you, Madam President. We do not have any questions.
Fine, then I was not that wrong, actually.
Yeah, you were right. Thank you, Madam President. Good afternoon, Mrs. Tomic-Brkušanin, and it's a pleasure to finally meet you.
Good afternoon, pleasure to meet you too.
My name is Petar Đundić, and I'm here on behalf of respondent in these proceedings. As you know, I'm here to ask you some questions about the 2 reports that you submitted. So let me first try to summarize my understanding of certain theses that you give in your reports. In your first report, you state that the transfer of shares under the Share Purchase Agreement, or the MDH agreement, and the SAMBI agreement was possible under Serbian capital market regulation. And you also submit that this was possible using the 3 different methods. That would be block trade transaction, an in-kind contribution of BD Agro shares into a newly founded LLC, and finally delisting BD Agro shares and subsequent transfer outside the Belgrade Stock Exchange. Is this correct?
Yes, that is correct.
So to clarify at the beginning, did the MDH and the SAMBI agreement, in your opinion, result in transfer of ownership in shares from Mr. Obradovich to MDH or SAMBI under the rules of Serbian law? So yeah, please.
Did the MDH and SAMBI agreements
Result in transfer of ownership in shares of BD Agro under the rules of Serbian law? immediately after the conclusion?
In terms of nominal ownership, they did not result in transfer because in order to change the nominal ownership, you need to be inscribed in the central registry as the owner. In terms of change of beneficial ownership, I was instructed that the law on Republic of Serbia is not applicable to these two agreements, so therefore that was not the object of my opinion. I opined on the consequences that those agreements would have in terms of the capital market law and in terms of the loan takeovers, and I find that they establish control of MDH and Zambi over BD Agro.
I understand,
Yes.
thank you. You are a lawyer by training, right?
Yes.
You are not an expert in conflict of laws, I'm assuming.
No, I am not. I was advised and instructed that the Serbian law was not applicable to these two.
I see.
Yes.
Have you consulted the expert opinion of Professor Uglješa Grušić as well?
Yes.
So you would remember that in his expert report, he claims that the regulation of capital market, or rather loan securities, 2002 and 2006 loan securities, they represent the so-called overriding mandatory provisions of Serbian law. Are you familiar with the concept of overriding mandatory provisions?
Well, Madam President, I object. There was a misrepresentation. Mr. Grušić certainly did not say that all norms of these two laws are overriding mandatory norms.
Fair enough.
Can you, maybe the last question, yeah, we've noted that. The last question is just, are you familiar with the notion of overriding mandatory laws?
I read Mr. Ugljesa's report, yes.
What about the concept of overriding mandatory rules in private international law? Are you familiar with the concept?
Yes, I also read that in his report. That is actually was not my area of opining.
I see. So you were referring to the concept of beneficial ownership in shares.
Could you please point me where I was talking about beneficial ownership?
Yeah. This is line 176-5. In terms of nominal ownership, they did not result in transfer because in order to change the nominal ownership, you need to be inscribed in the central registry as the owner. In terms of change of beneficial ownership, I was instructed that the law of the Republic of Serbia is not applicable.
Correct.
So
I was not opining on that. I was instructed that was.
Yeah, I understand that.
Yes.
I have a question about beneficial ownership of shares in joint stock companies under Serbian law. Are you aware of any court decision that has been rendered by Serbian court by which a natural or legal person was recognized as an owner of shares in a joint stock company that were registered in the name of another natural person?
Okay, I have to say that that was not the scope of my analysis, and I do not know about it on the spot, as that was not really in the scope of my work. I was advised that these contracts were not governed by Serbian law in terms of beneficial ownership, and that was not the scope of my work.
Thank you. So, moving to the so-called methods of transfer of shares that was within the scope of your reports. As for block trade transactions, I understand that block trade transaction is effectuated on the Belgrade Stock Exchange in accordance with the Belgrade Stock Exchange rules. Is this accurate?
Yes, that is accurate.
under those rules, under the 2004 and 2009 Belgrade Stock Exchange rules, a block trade transaction could be concluded only during stock exchange meetings. Is that correct as well?
Okay.
If you need some help, I can direct you to BCA rules 2004. This is Article 108, paragraph 3. This is Respondents Exhibit 323.
Yes, I am aware.
A block trade transaction needed to get an approval from an employee authorized by the director of the Belgrade Stock Exchange. Is that true as well?
Okay, I do not know these rules by heart. If you point me to the...
Yes, this is in terms of 2004 BCE rules. This is Article 111, paragraph 2.
Okay.
So this is correct.
Correct.
Can we now look at the paragraph 30 of your first report?
Yes.
So here you state that between 2004 and 2018, there was a requirement for a block trade transaction with regard to the maximum price deviation of 10 or 20% from the average price of shares achieved during the last 3 trading days, correct?
Yes.
So your report does not deal or does not try to answer whether this requirement was ever met when it comes to the MDH agreement. Is this correct?
Correct.
So do you know what was the price stipulated for the purchase of 70% of BD Agro shares in the MDH agreement?
Yes, I do.
Can you please share with us?
Yes, 1,000 euros, I think, or dollars.
I'm sorry, can you repeat?
1,000 euros or dollars, I think.
Yeah, precisely it was 1,000 euros. That is correct, and this is Claimant's Exhibit 15, of course. Do you have a general idea of what was the number of shares in the entire stock of BD Agro once those shares were listed at the Belgrade Stock Exchange? That was on March 12, 2007.
I do not know that.
Can we go to Claimant's Exhibit 526?
Okay.
So it was, and you will confirm, I hope, that it was a little over 700,000 shares.
Yes.
So 70% of that number would be in the neighborhood of 500,000 shares. Am I correct? 70% of 700,000.
Okay, I cannot calculate it right now, but I will trust you.
So this would entail that as long as the number of those listed shares remain the same, MDH would pay 1,000 euros for almost 500,000 of BD Agro shares.
Yes.
Does this sound accurate to you?
Yes, that was the price that was foreseen by the MDH agreement.
Okay, thank you. So let us look now at the next paragraph of your first report, that is paragraph 31. You find there that during the entire period, you're speaking about this requirement of price deviation, the BCE Board of Directors had the discretionary power to allow for a larger discrepancy in price. This is accurate?
Yes.
So I understand that the Board of Directors of the Belgrade Stock Exchange was under no obligation to allow discrepancy. they have discretionary power, am I correct?
Yes, discretionary power.
Thank you. Moving on to the next method, this is in-kind contribution. Now, I was hoping that you will help me understand. In-kind contribution would mean this: Mr. Obradovich would establish a limited liability company. Then he would transfer his shares in BD Agro as his
In-kind
yeah,
contribution.
in-kind contribution, thank you. Then the LLC becomes the owner of shares in BD Agro, and afterwards Mr. Obradovich sells his shares in this LLC to MDH or Serbia. Is this construction correct?
Correct.
Would it be correct to say that this option means that Mr. Obradovich and MDH or Serbia would need to conclude another share purchase agreement in order for Mr. Obradovich to sell his shares in that hypothetical LLC to MDH or Serbia?
They would have to have another contract in terms of transferring the ownership over the share in the LLC, yes.
Yes, thank you. And the last option would be delisting of BD Agro shares from the Belgrade Stock Exchange. To the best of your knowledge, have shares in BD Agro ever been delisted from the Belgrade Stock Exchange between 12th of March 2007 and 21st October 2015?
No.
Thank you. Please let us go now once again to Claimant's Exhibit 15, that is, again, MDH agreement. Article 2 of the MDH agreement, as far as I understand, it contains or provides for the transfer of shares outside of the stock exchange. Is this correct?
This provision says that the share transfer will be executed through duly endorsed share certificates.
So this would be, I assume, outside Belgrade Stock Exchange?
Yes.
Thank you. Now, in your first report, you stated that you disagreed with Professor Radovich about the interpretation of the 2008 decision of Serbian Supreme Court. Do you know to which decision I'm referring? This is Respondent's Exhibit number 2.
Yes, I do. I know.
So, so please refer to the paragraph 71 of the first report.
71. Okay.
You state there, first, Dr. Radovich incorrectly insinuates that the contracts on sale and purchase of shares addressed in the decision 438/2007 were null and void because they had been agreed outside the stock exchange. And then you continue to say, in my opinion, the Supreme Court held these contracts invalid because they provided for transfer of shares outside of the stock exchange. This is your position.
Yes.
So, in your interpretation, the Supreme Court of Serbia considers null and void contracts that provide for transfer of shares outside of stock exchange. Is this correct?
Yes.
Thank you. So my next question concerns the rules on takeover bids. And this was described, or one of your thesis was described in paragraph 88 of your first report.
Mm-hmm.
So there you state, the conclusion of the MDH agreement was not subject to any takeover rules. The takeover rules under the 2002 securities law only applied to transfer of nominal ownership in a joint stock company. because the conclusion of the MDH agreement did not cause transfer of nominal ownership of any shares, its conclusion did not trigger the takeover rules under the 2002 securities law. This is
Yes.
your position, basically, that the takeover rules from that 2002 securities law applied only to the purchase of nominal ownership of shares.
Yes.
Correct? So what about acquisition of beneficial ownership? Did the rules on takeover law provide any protection of minority shareholders in case of such takeover through acquisition of beneficial ownership?
In 2002, no. Only when the new takeover law in 2006 was adopted.
So are you saying that the 2006 takeover law contained protection of minority shareholders in cases of beneficial takeover?
In cases of?
Beneficial takeover.
In the case...
I'm referring, I'm sorry, maybe this is not fair to you. I'm referring to the case in which a company or an individual, an entity, does not take over nominal ownership in shares, but it becomes what is known as beneficial owner. So this takeover law, as I understand, applies only to the transfer of nominal ownership.
2006 takeover law?
Yeah.
No, not only nominal ownership.
Could you explain?
2006 takeover law was introduced to basically protect minority shareholders against change of whether direct but also indirect control, wherever there is a factual shift of control in the company, whether or not the nominal shareholding has changed and nominal control. Therefore, if you have, for example, indirect change of ownership, or you have the contracts which do not even have to be written down, they can be oral, the agreements can be tacit, they don't have to be expressed. Whenever you have a real change in control, the trigger, the obligation to publish a mandatory takeover bid is triggered. And I think there is details on that.
You are basically saying that an indirect owner of a company comes under the scope of obligation in 2006 takeover law.
Yes, and not just indirect owner. Any person who can influence the company's business operations in a meaningful way.
I see. So moving on. This is another question that concerns takeover bids. This is a question that goes to the failure of Mr. Rand, Sambi, Mr. Obradovich, and MDH Serbia to issue a takeover bid once MDH Serbia started acquiring additional 3.9% of shares in BD Agro. So you do remember?
Yes, I do.
Okay. So in paragraphs 69 and 70 of the second report, you state that the Securities Commission could not sanction Mr. Rand, Sambi, Mr. Obradovich, and MDH Serbia with the loss of voting rights of all persons acting in concert. Is this correct?
Yes, I do.
So would you like to elaborate on why is this so?
Because the sanction you are referring to, where you take all the voting rights in the target company, once you have reached the obligation to publish a mandatory takeover bid, was introduced after the breach of the takeover law has happened. And you cannot retroactively apply this sanction to a breach that happened prior to its adoption.
So when did the breach exactly happen?
I do not know it by heart. We can look at it.
But it is your opinion that it was before 2012, right?
Yes, it was before 2012.
So the new law containing the new sanction,
Yes,
it came in force on 4th February 2012, if I'm correct.
yes. And the first acquisition of first share
Mm-hmm.
outside of those that were issued in the privatization scope would come under the effect of the takeover law, and that is when the breach would happen, and the law applicable of the first acquisition would be applied.
Right. Can I take you to Claimant's Exhibit 545? So this is the text of the amended law. This is so-called 2011 takeover law.
Mm-hmm.
I'm interested in Article 49, which is in Serbian. So claimants did not submit the translation of this provision in Claimant's Exhibit 545. This is the Serbian text. But this provision is exactly the same as in the previous law, and this is Claimant's Exhibit 540. So these are, I don't know if you can see, these are the two provisions.
Yes, okay.
On your left is the provision from 2006 takeover law, and on your right would be the provision, Article 49, from the amended law, in force since February 2011. Can you confirm that those provisions are in fact identical?
Yes, they are.
Okay. So the English translation of Article 49 in Claimant's Exhibit 540 is as follows. Shareholders who own 25% of the voting shares in a joint stock company on the day this law comes into force and have the intention of acquiring further voting shares of that company after this law comes into force are obliged to carry out a takeover procedure in accordance with provisions of this law. So this is a transitional provision, correct?
Yes.
This is meaning the provision that establishes the temporal scope of the law. So would you agree with me that this provision basically says that if a shareholder who owns 25% of the shares continues to acquire shares after the 4th of February 2012 comes under the purview or scope of this new amended law as well?
No, I would not.
Would you care to explain?
Yes, because the obligation, it was really a matter of many discussions in the SEC, whether the obligation to publish a takeover bid can be breached once or numerous times. And the conclusion is that you look at the first time the obligation was breached, the further shares that you acquire after that are actually the breach of different article of the law, which says you cannot, after you have passed that threshold, any further acquisitions are forbidden. But it is not that this provision cannot be retroactively applied, because for the first time you have breached the obligation to the takeover law. That is the time when you look at the applicable law. Later on, you're constantly in breach, but the time of the first breach is the one that is relevant for the law that needs to be applied. And actually, I submitted the court decision where the SEC tried to retroactively apply this, and the court said it is the retroactive application of the law.
You do agree that this is what Article 49 of the 2011 takeover law says? I mean, what is your interpretation of this provision, if not in a way that
if you have, this would apply if you were not already in breach. But if you are already in breach, you need to apply the law which was in the force at the time of that breach.
Okay. So we can maybe come back to that later on. So the final set of questions that I intended to ask you, they concern the issue of control over companies in Serbian law. In your second report, and this is section 3.a, you say that Mr. Rand exercised control over BD Agro from October 2005 and October 2015. So,
Could you please point me to the paragraph?
yeah, those are paragraphs 8 to 27. I understand that probably this is not the best time for you to read paragraphs 8 to 27, but generally, am I right to say that it is your opinion that Mr. Rand exercised control over BD Agro from October 2005 until October 2015?
Yes.
So your conclusion is based on provisions of the 2006 takeover law and the 2011 capital market law. Is this correct?
Yes, that is correct.
If I can refer you again to the Claimant's Exhibit 540, Article 4, Paragraph 3 of the 2006 takeover laws. It says here, in the sense of Article 2 of this article, it's supposed to say in the sense of Paragraph 2 of this article, it is considered that the natural or legal person controls a legal person if it has, and there the provision continues. The notion of control in this paragraph was given for the purpose of establishing of acting in concert or acting together, acting in accord. Is this correct?
The purpose of these provisions is to protect minority shareholders against the change in control of the target company and to protect
Yes,
their rights. Yes.
Mrs. Tomic-Berkushin, I understand. But the definition of control that is contained in paragraph 4, in Article 4, paragraph 3, is given in the sense of a previous paragraph which defines acting in concert. Am I correct?
Yes.
Thank you. You also rely on Article 2, paragraph 1, item 29 of the 2011 Capital Market Law for a definition of control. This is Claimant's Exhibit 728. So, yeah, Article 2 defines terms in the context of this law. Do you accept that?
Yes, I do.
Okay. Let us now look at paragraphs 25 and 26 of your second report. In paragraph 25 of the second report, you state that you disagree with Professor Radovich's conclusion that the notion of control under the 2011 Capital Market Law refers only to the relationship between a parent company and its subsidiary. This is correct?
Yes.
So you continue to explain in next paragraph, this is paragraph 26, and I quote, Article 2, paragraph 2, item 30 of the 2011 Loan Capital Market expressly provides that control means the relationship between the parent and the subsidiary in all cases referred to in item 29 of this paragraph, or a similar relationship between the natural and legal person and the company. So this is accurate. At the item 30 of Article 2, Paragraph 2, going back to Claimant's Exhibit 7 to 8, was meant to define the notion of close links. Am I correct?
Yes, but close links, when it comes to control, are in the point number 2.
I understand that. But this is the definition of close links and not the definition of the notion of control.
But within the definition of control for those close links.
Yeah, establishing close links through means of control. That would be the.
Yes.
Okay. Thank you, Mrs. Tomic-Brkušanin. Once again, this is all that I had for this.
Thank you.
Thank you.
Any questions in the redirect?
Yes, Madam President.
Yes, sure.
Mrs. Tomic-Brkušanin, you were asked a few questions about your paragraph 31 relating to the Belgrade Stock Exchange Board of Directors and its discretionary power to allow for a larger price discrepancy for block trades. Do you recall that?
Yes, can you please just tell me, are you talking about the first? Okay.
Yes, first, yes. Mm-hmm.
Yes.
My question is simple. In your experience, did the Board of Directors allow for a larger discrepancy in price?
Yes.
Then you also got a question about Article 2 of the MDH agreement and the fact that it foresaw transfer of share certificates by their endorsement. Do you recall that?
Yes, I do.
Do you know whether BD Agro had share certificates that could be endorsed?
Yes, I do. They did not.
And finally, you were shown document 323, which is the operative rules of Belgrade Stock Exchange Market in I don't know if that could be, please, Article 108, if that could be put on the screen, I'd be very grateful. Yeah, there's one thing which surprised me because you were taken, as we have seen right now, to paragraph 3 of that provision, and there also is paragraph 2 of the provision. Paragraph 2 says block transaction is transaction concluded outside of stock exchange meeting on which it is traded by the method of prevailing price or by method of continuous trade in bilateral relation of one buyer and one seller. So that's what paragraph 2 says. And then in paragraph 3 it says block transaction can be concluded only during stock exchange meeting, which to me seems to be in contradiction with the beginning of paragraph 2. So could you please explain or comment on these two provisions? Thank you.
I think this is not really a good translation. That is why I was confused. They are concluded outside of the stock exchange session, but during stock exchange meetings. So, but I think what is really important about block transactions, of course, they will be executed on the stock exchange. But the matter of fact is that the parties needed to agree that they will execute that block transaction. It was virtually impossible to execute a block transaction without previous agreement because of the conditions under which block transactions actually happened on the on the Belgrade Stock Exchange. You needed to have matching of orders of buyers and sellers in all important elements in the matter of 15 minutes. So there were always agreements that the parties will execute a block transaction. It needed finally to happen on the block exchange meeting outside of the regular trading sessions.
Thank you, and thank you. I have no further questions.
Thank you. Do my colleagues have questions? Yes, please.
Good afternoon.
Good afternoon.
I just wanted to understand a little more about the discretion of the board of the BSE on a block trade which deviates more than a particular amount on the price. Do you know what dictates their discretion? In other words, are there guidelines or what under what circumstances? And I heard your answer to council that they do it. I'm just interested in when or why or...
As an employee, former of the SEC, I know we do not have that information. That was basically their complete discretion, and it was like that in the rules itself. It did not say they have a discretion within these parameters or etc. They just have a complete discretion to decide.
Thank you.
Yeah, so good afternoon, Madam Tomic Brokushanin. Just one question. At the very beginning, you mentioned that you were requested to consider that the Serbian law is not applicable for your analysis. Could you tell me which areas of Serbian law you didn't take into account, or you put aside, or you were requested to put aside? You mentioned conflict of laws in the
What I was
first time,
yes,
but
I was advised that even though the Serbian law was not competent for these agreements, that they still needed to be executed, of course, in Serbia and on the Belgrade Stock Exchange. So I was looking at the securities laws applicable to that transfer of shares. So I was looking at the takeover law, securities market law, and capital market law in terms of the possible methods how parties could effectuate basically the transfer of shares under MDH and the SEMBI agreement.
okay, it means that you didn't take stance about potential consequences of the applications of other Serbian legislation.
I'm sorry, of other?
Yeah, my question is whether you didn't take stance about the actual or potential consequences of the application of other Serbian legislation.
Yes, I was basically talking about the capital market regulations. That was the scope of my analysis.
Thank you. No further question, Madam President.
Thank you. I had questions, but they have been asked, so I have no further questions. Thank you very much. That completes your examination. So we're doing better in terms of time than what we had expected. Let's just look at the program. There's one question about interpretation. I understand that there's no further witness who will speak Serbian except for Mrs. Ilic, who is heard on Monday. Is that right?
Yes, that's right.
Yes, you do not expect someone to want to change like I think Mr. Cvetkovic did today.
No, we do not expect that.
Good. Does that mean that we can tell the interpreters that we don't need them tomorrow and Saturday?
Yes.
And only to be back on Monday?
Yes, that's correct, Madam President.
Good.
Madam President.
Is this agreed on your side as well, or do you want them here?
Yeah, I think it might be helpful for the interpreters to be present for the cross-examination of Dr. Milosevic on our side. He will definitely be answering in English, but he's less sure. There may be some expressions that he might require help with.
Yeah, it may be helpful
We agree
to have them there. Yeah, we have to see whether we want them to interpret constantly or just be available in case we need help. You can consider this and we can decide tomorrow morning.
Yeah, what we had in mind was like being available in case of need.
Yes. Is that what you have in mind too?
Yes, of course, no problem.
Fine, so they hear us. We would expect them to be here and and just follow the discussion in case we need help on it, mainly, I suppose, on a specific term, but without having to interpret the discussions. Good. And then in terms of timing of the witnesses, so we'll start with Mr. Milosevic tomorrow, and then we will hear Ms. Grusic. Mr. Dean, I think, is by video conference, is that right? And is he planned for a certain time?
That's correct, and he's planned for a time because he is in Vancouver. I just sent him an email asking whether he could be available a bit earlier, given that we are ahead of the schedule. I will be happy to report on that as soon as I can.
Now, do we want to take someone else tomorrow? The next one would be Professor Obradovich, or not? Or we can just reserve the possibility?
Of course, no problem. Professor Radovic will be available to be cross-examined tomorrow.
And
yes.
Yeah. So on our side, because there's the issue with Mr. Dean.
Yes.
So it depends a little bit on how much time you want to spend with Mr. Milosevic and Mr. Grusic, so that we then know how much time we have in the afternoon, because we will need to do the cross-examination of Mr. Dean on that day and at the specific hour.
If I may, I do not foresee that it will take more than 45 minutes that are reserved for Mr. Grusic. So basically, we will keep that into the schedule.
But if we're done too early for Mr. Dean's time, because he must be about 9 hours behind us, right? Then could we start with Mrs. Obradovich, do Mrs. Obradovich first?
Or maybe, Madam President, we can start at 10 tomorrow morning.
Oh, we are starting at 10, that is already provided. Yes, absolutely. We're not going to change this, I suppose, because everybody will enjoy the time tomorrow morning. But,
definitely.
So maybe it will not be needed, and we're in time for Mr. Dean.
Look, the only thing is for us to know whether we should have the binder ready for Mrs. Radovic or not.
I think it's better
we will have it ready.
You prepare it if you can tonight, and then we can leave some flexibility and see where we stand tomorrow at lunchtime.
Perfect.
We agree.
The only thing we would like to avoid is that we all sit here and have nothing to do and but cannot leave because we have another examination coming.
We can also agree that we will split Professor Radovic's cross-examination, right? The scenario I am afraid of is that we have just like 1 hour before the hour for Mr. Dean. Then the question will be, do we start the cross-examination knowing that we will not be able to finish it within that 1 hour, or we just postpone it for Saturday? But we may decide that tomorrow.
That's for you to say, but maybe we cross this bridge when we get to it, because maybe it won't occur. Right? Maybe we can finish Professor Obradovich, maybe we cannot even start, and maybe we can do parts of it tomorrow and the rest on Saturday, and then we will see that is acceptable to everyone.
We agree.
Fine.
May I ask you at what time it is envisaged to have Mr. Dean?
So I think currently it was
our time, I mean.
Yeah, it was 5 p.m. if I'm not mistaken. But I sent him an email message inquiring whether he would be available earlier.
9 hours.
So 17 minus 9 is already 6 o'clock for him.
It's 8 a.m. his time.
Good. Good for me. Yeah, so maybe he can get up earlier. Yeah. Good. Fine, so you'll tell us.
We will send an email when we hear
Yeah,
from him.
maybe that's better, so everyone is prepared accordingly. Is there anything else we need to discuss now?
Nothing for the claimants.
Thank you. On the
No, thank you, Madam
respondents then?
President.
No? Good. Then I wish everybody a nice evening, and we'll see each other tomorrow at 10 o'clock, right?